Hey, what's up? They are not back in court yet. I got to go hang out my old stomping grounds on Recovery Addicts channel for a while. That was a lot of fun. What? Not ready. Because I'm so not professional. Goodness. I'll learn how to do this one day. So they are not back in court yet. I guess they're still doing the charging conference or eating lunch or doing both maybe in chambers. I don't know. Watching some fun stuff over on Recovery Addicts channel. Some dude having a fit about his lawyer complaining to the judge. Forgot. There was one before that one was good too. I forgot what that one was about. His mod. He has a mod that is amazing at finding the most outrageous cases in the world. I don't know how he does it. And then I offered, because remember that soft sit that we did? When was that? I don't remember. But this soft sit that had his laughing czar, we were crying the other day. I offered, because we watched, the first time I saw that was on his channel, but he hasn't seen it. So I offered that to him, and he's like, no, McBurney's court has the worst sound. I'm like, well, sound fine on my end. But RA is like a Can I sue StreamYard for violating my First Amendment right to free speech? It keeps muting me. So as I was saying, and I say this in love, RA is a sound snob because he has all this amazing equipment that can fix sound, but he says the sound in McBurney's courtroom cannot be fixed. It sounded fine to me. I know. He's like, we should have counted the grunting. But after the Ferris trial, he promised to never count anything that one person did again. And I'm like, but do we care? With this one person, do we care? But he counted, what's her name? Shannon with the oh man, the name is on the tip of my tongue. I can see her face. Not her name. Crumbly. With a Crumbly trial. Her sorries, he counted her sorries. And then he felt bad about that, but she wasn't offended. And then he counted the judge in the Ferris trial, his ums, and he wasn't mad about that. So I don't know why he stopped doing that. And the made-up word counter was because of Kelly, because of the defense attorney Kelly. He's the one that makes up the words, so that's kind of one person. I mean, maybe some other people might have made up some words. But he said that he basically did that because of Kelly. So there you go. Why not count Grutz? But he said he should have. He didn't know he was going to need StreamYard. I don't have the patience for this today. Yeah, mine get mad at me all the time for not sharing. I try to tell them Just because it goes in my mouth does not mean it has to go in yours. I shared with him today, I had chicken fettuccine Alfredo. And they got some chicken and they got some noodles. One day, because I eat when, well, actually, I've got Travis eating them now. I eat the lean cuisine frozen dinners. And my Travis is a wonderful man, as you all know. He bends over backwards to treat me like a princess. But he's a tad lazy. And so there's these lean cuisines that are called steamers. And it's got 2 plastic pieces in it, and the sauce is in the plastic thing on the bottom, and the plastic thing on the top has the vegetables and the meat in it with holes, and it's got the plastic wrap on the top, and you don't have to poke holes or anything. You stick the whole thing in the microwave. It stays in there for like 5 minutes or whatever. You take it out, and then you just peel the top off and you pour the vegetables and stuff into the sauce and mix it up. I don't like those. I don't know why I don't like them. I don't know if it's because it's steamed and the vegetables aren't cooked soggy. I don't know what it is. Shadow won't eat people food. She'll beg for it, and then I'll give it to her, and she sniffs it and walks away. I've never had a cat that won't eat people food. But I had a couple left over that I bought and realized I didn't like it, and they were up there, and so he ate them one day and he really liked it because I like these better. I was like, okay, well, I'll start getting those for you and I'll get the other kind for me. And so one day I was like, why do you like those better? He goes, because they're easier, because I don't have to poke holes in the top. I was like, what? I was like, that is the epitome of lazy, Travis. But then I was making them. I mean, usually we make our own, when I'm like, no, we're having a frozen dinner night. He makes his, I make mine. Unless for some reason I'm in the bed on a heating pad because I'm not feeling well, then he'll make mine for me and bring it to me. But usually we make our own. So I made his one night and I'm like, oh, I think it's when he sprained his ankle. I made his for him. And I was like, oh, well, now I know why he likes these better. Because with mine, you poke holes, which is no big deal. But you put it in for like 2 minutes, and then you have to pull the thing back and stir the sauce in with the noodles and the meat and the vegetables. Put the lid back, and then put it back in for another 2.5 minutes, whatever. That's what he doesn't like doing. He doesn't like, you put it in, and then you go sit down, and you got to get up and you stir it, and then put it back in, and then wait again. So it's not lazy, it's inconvenient. So I get it now, but still, it's a frozen dinner. It's much more inconvenient for me to have to cook a whole meal. I hate cooking. But one day I was eating, I love fettuccine Alfredo. The good, the bad, the lean cuisine, the box, the homemade, you name it. If it's fettuccine Alfredo, I'll eat it. So I was feeding them one day and I wasn't paying attention. I was sitting here at the computer and I'm just dropping. I think I was streaming and I had the camera off so you guys didn't have to watch me eat. And I was just dropping noodles. And a little while later, I was done eating and I was still streaming and I look over at Spike. He had a noodle right here. Like, come here, dude. Let me get the noodle off your face. One time he was in the bedroom and I had cheese and I was sitting on the bed and I was tossing cheese to them and one landed in the middle of his back and he's looking all over for it because like he saw me toss it but he didn't see where it landed. He's looking all over the place. He's just like, where'd it go? I'm like, it's on your back, dude. Come here, let me get it. He's looking all over. Come here, it's on your back. I don't know how he doesn't feel the food when it lands on him, but he doesn't. and he looks all over for it. So I share. The one thing I can't share with them, Lean Cuisine makes this, they call it a chicken fajita quesadilla. Is it a fajita or a quesadilla? They can't decide. But it's a tortilla, and it is just smothered in chicken and onions and peppers and cheese. And it goes out to the very edge of the tortilla. And then you can either microwave it or air fry it, and then you fold it in half and you eat it like a taco or tortilla, or I mean fajita or whatever. I don't know what it really is supposed to be, but it's good. But the onions and the peppers go to the very edge, so there's not like a piece that I can even get off and give them unless I scrape all the stuff off of it. So they just get a teeny tiny piece of me because I'm not sharing. Like, I'm sorry, guys, you can't have this, because when I make homemade ones, they get great big strips of tortilla off the sides because I don't eat all that breading, because that's the bad part. I make the lean chicken with the peppers and the onions, and I put that in the center, and then I give them the leftover bread off the sides. So, but yeah, they get all kinds of people food. They love it. I can't imagine a dog not eating people food. I've always had cats that like people food too. The only people food Shadow's ever had is tuna fish, because that's how I got her. She was born in my shed, and I didn't have any cat food. I had no cat food, any canned cat, because I had one cat at the time. I think I had one at the time. Yeah. So, I fed her tuna fish. That's how I got her inside. But cheese, she'll sniff it and walk away. I had a cat one time. I made lasagna. She jumped up on the stove and was eating out of the pan of lasagna. I'm like, you're not Garfield. Get off the stove now. I had another cat when my dad, remember I told you guys my dad was in the hospital in 95 for like 12 weeks or something like that. We had the sweetest cat, and I took this cat with me to the hospital because it'd been so long since Daddy had seen him. And I had a tote bag, and I stuck him in the tote bag, and my aunt always made pound cake. Like, she always had pound cake. This woman never was without pound cake. She'd make like, I don't know how many at a time. She'd take them to everybody. We always had pound cake. She'd take them to church. Like, always had pound cake. So my cat loved her pound cake, so I put pound cake in the tote bag so he would stay down in the bag when I was walking into the hospital. And then when he was in a private room. We got to the room. I let the cat out. The cat laid in the bed with him and just laid there next to him and purred while my dad pet him. He was so happy to see him. The doctor came in, and I'm thinking, oh crap, they're gonna throw us out of this hospital because we've got the cat in here. And the doctor didn't say a word. Sat down on the bed, talked to Dad, examined him, everything. As he's walking out, he turns around and he looks at the cat. He goes, man, that is one mellow cat. And then just walks out of the room. But then later, after my dad had surgery, they had to put him in. It wasn't the ICU, it was the step-down ICU. He wasn't sick enough to be in the ICU, but he needed more like closer monitoring, but he wasn't that sick, like medium monitoring. So I took the cat with me that time, but he was curious. There was too many bells and whistles and stuff, and he wanted to see everything. I'm like, okay, well, that doesn't work in the step-down ICU, but in the room he was fine because it was just a bed and, but now they let animals go in the hospital all the time. because they're therapeutic, there's a limit, but still. I said something on, I think it was on X, I said something about taking my dog to the hospital. It was part of a larger conversation about animals, and somebody was telling me how wrong it was for me to bring a dog into the hospital, and I got hot. I'm like, well, number one, nobody said anything to me about it. Number two, somebody else came in with a dog while I was there, and number three, I'm a nurse, and they have rehab dogs in the hospital all the time. And one of the nursing homes that I worked at had a dog that lived there. It's not anything that raises somebody's spirits is good for their health. And if you're used to having dogs and you're sick, having a dog around makes you feel better. And therapy dogs go, like we were talking earlier about emotional support animals and service dogs, they go through training and stuff. And there's rules. They wear those little jackets that say working, do not touch, and stuff like that. They're not just whatever.
On the record, in the case of People versus Linda Stermer, the jurors are not present. They're in the jury room. The record should reflect I've met on 2 occasions now with counsel to go through final instructions. And at this time, I will place on the record the instructions I intend to provide, and counsel can then indicate if I'm wrong in any way based on what we discussed, or any objections you can place on the record too. So I'll be providing 3.1 duties of judge and jury, 3.1 counsel. 3.2 presumption of innocence, burden of proof, and reasonable doubt. 3.3 defendant not testifying. 3.5 evidence. 3.6, I'm sorry. 3.4, what's, I don't have that in mind.
3.4.
I don't have one. Okay. I don't have that in the list. I don't know offhand what that one is, but.
They didn't.
Are you just mentioning that because I skipped a number?
Surgery?
Or,
Yeah, that's what we just got to do.
okay. Did,
3.4 is inducement by prior conviction. We had none of that.
oh, so 3.4 doesn't apply. Okay. 3.5 evidence, 3.6 witnesses credibility, 4.1 defendant's statement against the defendant, 4.3 circumstantial evidence, 4.5 prior inconsistent statement used to impeach a witness, 4.7 stipulation, 4.9 motive, 4.10 transcript of prior testimony, 416 intent, 5.2 weighing conflicting evidence, number of witnesses, 5.3 witness who has been interviewed by a lawyer, 5.10 expert witnesses, and that single instruction applies to all those who testified as experts in this case. Demonstrative exhibits, 5.11 police witness, then we move on, counsel, to the elements of the offenses. Initially, I'll note that after discussion with council, it's my understanding that council are in agreement that as to counts 1 and 2, the jury will be provided with the option of the lesser offense of second-degree murder. Is that correct, council?
That is correct, Your Honor.
Yes, Your Honor.
Okay. And no one has requested manslaughter instruction of any sort. Is that correct?
I have not, Your Honor.
Am I correct, Mr. Kelly, that there's no request for a manslaughter instruction here? Is that correct?
Yes, Your Honor.
Okay,
Wait, is that a lesser
so
included offense?
charges count 1, and then including the lesser of second degree. Count 2 elements will be provided. Felony murder, again, on that count. After discussion, we will be providing the lesser of count 2 on that one. Time and place venue. 16.21, inferring state of mind. 311, deliberations and verdict. 313, penalty. 314, communications with the court. 315, exhibits, and we're still waiting some of the defense. And exhibits, counsel will need to get defense. I think we have all the prosecutors, but you will need you to gather up the exhibits that have been admitted.
Your Honor, we do have a tote sitting behind me then of all the physical evidence.
Okay.
So if the jury, or we'll turn it over to the custody of the court.
Yeah, we'll get it in the jury room. So as soon as possible, once we're done with closing arguments and we get the case, get the jury in the jury room, if you could help us figure out where your exhibits are so we can get those to the jury. Witness written instructions, I'm sorry, 316.
Felony murder.
Single defendant, multiple counts, more than one wrongful act, 320. Verdict form, 323. Counsel have been provided with the verdict form we intend to provide to the jury.
I don't see anything about
The record sure reflect too, we did have significant discussion about the unanimity instruction, and I think everybody came to the conclusion that the way the charges are presented, that it was maybe more confusing than anything for the jury, so we're not providing that instruction. Is that a fair summary?
Just that we're providing the standard instruction. I think what we talked about is that we took away the unanimity instruction that we thought pertained to open murder, but we kept the standard unanimity instruction for both counts.
Correct. Is that your understanding, Mr.
That's
Kelly?
correct, Your Honor.
Okay. So counsel, and you both have I know we talked about a couple different verdict forms. You both have the final one we intend to use for approval.
I have the one that we discussed. I don't see
Okay.
one attached in here. If it's the same one that was discussed prior to our break, or at our break, then I do have it.
Okay, it is that same one.
Okay.
I thought I had a copy of it.
Let's see. It might be back at his desk. One moment, we're going to gather that form just so we're all looking at the same item. While I'm waiting for that verdict form, to the media who's here, there's going to be a point where we release jurors. So I would prefer if you could not film that part when we're releasing the alternate jurors in the case, okay? Off a click or what, but. While we wait for the verdict form, Mr. Mueller or Mr. Kelly, did you have objections to the ones I intend to provide, or did you have special instructions or other instructions you're requesting?
Yes, Your Honor. As we noted, we requested a spoliation instruction, adverse inference instruction with respect to the in-car video from Deputy Russ, which was showed in plaintiff's exhibits 10 pictures taken over 9 seconds. Deputy Gruss said it was from his in-car video. He didn't know where it went. Prosecutor apparently didn't know where it is. It's never been turned over to us. Our argument is that clearly a video is way better than 10 pictures over 9 seconds in terms of showing in real time the progression of the fire. As the court knows, one of the big issues in this case is the speed of the fire, where the fire was located initially.
Complaining about.
We think because it's the obligation of the prosecution and the sheriffs through the prosecution to turn that over in discovery, we've been hamstrung by that. We've been prejudiced by that. We would request an adverse inference instruction that had it been produced, it would be disfavorable to the prosecution.
Thank you. Prosecution response?
Your Honor, what I can say is this, because this is kind of encompassing a discovery issue as well that I think we've actually talked about before. This video back in 2007, if we have any question about that, I have actually Detective Roman here, you can speak to that as well. They use VHS tapes in the patrol cars. And I understand Mr. Gruss maybe not been very clear on that, but they use VHS tapes that were reused and recorded. I can speak to that. Even in 2009, when I started here, VHS tapes were used because I used to get them in cases. And unfortunately, those tapes were reused and were sometimes corrupted and didn't work properly or whatever. My understanding is these stills were taken from the videotape because the videotape itself was not in good working order. That's why we have where we're at this point in time. They are a representation of what was on that videotape. It is all we've ever had in our possession since we took over, President and I took over this case. And even prior to that, the original case file that we had in our office never had that videotape. I've been through all the evidence in the sheriff's department. There are other VHS tapes present there of different interviews and things, but this videotape has never, ever been located. All we've ever had is still photographs, which have been turned over as part of evidence. In the case from the onset, there is, I don't think there's any justification for a spoliation or an adverse instruction against the people. There's no legal justification, no case law in support of this, and I don't think it's appropriate for the court to give such. Thank you.
Thank you. And I think you were indicating those were, instead what you have are these 10 photos that were taken
Yes.
over how many seconds?
9 seconds.
9 seconds. Okay, the defense is requesting a special instruction as it relates to this video. The court finds that, that I'm not going to provide the instruction. The defense has not demonstrated to this court that the government acted in bad faith in any way in failing to preserve the evidence, or that the nature of the evidence was such that the defendant would be unable to obtain comparable evidence by other reasonably available means. The court is citing People versus Cross reversed on other grounds. If the court uses the missing witness instruction, then the issue is whether the prosecution exercised due diligence. But in any way, in any event, under either standard, I find that the defense has not met its burden to get the instruction.
May I give a 30-second response, Your Honor?
No, thank you. And counsel, in the meantime, did you get the
I've not seen it.
Okay.
Email.
oh, it should be on the verdict form?
We have a written one, but I don't.
Oh, you want an email?
Yes, and
Okay.
he said he emailed it, but there's nothing coming up.
Give me to forward that email to you, Wolf, that I got.
Please.
Oh, wait, Jay might be on the case here.
Yeah, it was sent to all of us.
It's not on your emails?
No.
I have it.
We just,
Okay.
he just.
I just forwarded it to Mr. Mueller. Hope maybe it was a.
And this is the one do you have it yet, Wolf? On your email?
I don't have
Oh,
the, I
you-
think
you
Joe
just
was
need
the
it on
email.
your-
It said he emailed it, but I haven't seen it.
Okay. So I think Jay just sent it to you, because you need it for your closing, right?
I'd like to have
Yeah.
it loaded up. No, I'm going back to before noon, Your Honor.
No, I think Jay's gonna try to get.
I did. I
it.
just emailed it.
Here we go, I got it.
Okay.
Finally.
Defense, are you good with the form of the verdict form, providing the option on each count of not guilty, guilty of first degree, or guilty of the lesser?
You guys, I have been begging. I'm sorry. My mind wandered. ADHD strikes again. I'm sorry. I have been begging the behavior panel to do an episode on Jen McCabe, and they finally did it. Finally. It's live right now. But don't leave. I'm going to watch it later. Watch it later.
Offense of second degree?
Yes, Your
Okay. And I know, Wolf, you're waiting to get yours.
Just 5 minutes real quick.
Okay.
I got the email, I'm just trying to,
You put it into your
please.
PowerPoint or whatever, okay. The jury has pizza, so they won't mind.
Ooh, what if they watched my video and decided to do it? Oh, no, they couldn't because it's members only. Never mind. I don't, I'm full. I just ate.
Thank you, Your Honor.
You good?
I'm good. That's it.
No, you're not. You're a horrible man.
Do you have what you need, Mr. Mueller? Are you good?
I'm good, thank you.
Okay. Anything else, counsel, before we bring in the jury for closing arguments and final instructions?
I have nothing, Your Honor.
He has no lesser included.
Anything else, defense?
No, Your Honor.
No? Okay, we'll bring in the jury.
She's got first degree murder, felony murder, and arson. And the crazy thing is that I kind of think she did it, but I kind of don't think that they proved it because there is reasonable doubt.
Welcome back, jury. As I indicated, we are now at closing arguments inside of me.
Thank you, Your Honor. Good afternoon. First of all, I want to take this opportunity to thank you for your time and your attention over this very long 3 weeks. It's obviously been paying attention, and the questions were very thoughtful questions, and we appreciate that. So, what is the closing argument? Closing argument is an opportunity for us to rehash what you've heard, kind of condense it down. It's been a lot of information, a lot of witnesses, just a chance for us to summarize. And it's also a chance for us to give you our theory, what we think happened. So let's jump in. We talked in the beginning, I think in our opening conversation, about the two charges. We have a first degree murder and we have a felony murder, 2 counts. That's what you're going to be deciding and looking at. So again, going back to the boxes that I have to check. That's what we talked about in voir dire, right? Those boxes, those elements. So you can see on the screen what the elements are. defendant caused the death of Todd Stermer, that the intent to kill was premeditated or thought out beforehand, and that the killing was deliberate. There's some definitions there, which you will have. The judge will give you all of this in writing, but that's really breaking it down to the simple form. Let's take a look at count 2. That's your first-degree felony murder. 3 boxes I need to check. First, that the defendant caused the death of Todd Stermer. Second, that the defendant had one of 3 states of mind. She intended to kill, or she intended to do great bodily harm to Todd Stermer, or she knowingly created a very high risk of death or great bodily harm, knowing that death or such harm would likely be the cause of her actions. And third, that when she did this, when she caused the death of Todd Stermer, that she was committing or attempting to commit the crime of arson. So those are your 2 counts. But within that, we need to take a look at arson, because that's part of that last element. So what are the boxes for arson? That the defendant burned a building, that at the time of the burning, that the building was a dwelling house, it was a residence. Third, that when the defendant burned the dwelling, she intended to burn the dwelling. And again, there's a little bit more description there, which you will have a copy back in the jury room. But that's broken down simply. Those are the boxes. So let's talk about the evidence that you've heard now for 3 weeks. Because every witness is only one piece of this trial. You are the fact finders on whether these crimes were committed. And it's taking all of the evidence into account. So let's take a minute to look at the evidence. First of all, you heard from Sandy Stermer. She's the mother of Todd Stermer, victim who died in this case. Todd and Linda were not in good financial standing. You heard lots of testimony about that. The loans, being behind on bills, never able to pay the bills.
I don't think they proved it.
Sandy talked about how Todd was in good shape. He was an athlete. There was discussion about how he was a coach. Todd built that house that burned on January 7th of 2007. And Sandy described her son as a perfectionist. Linda relayed little detail,
Usually, but I don't know
facts about
on
that
this.
fire to her in the stories that she had. Sandy. Twice, Linda said she went out the basement door, and once she said she exited out the front door. You next heard from Tony Evans. Tony, Deputy Evans, was the first deputy to arrive on scene at that residence on County Road 215. He observed the Stermer residence to be on fire. Flames were coming out the 2nd floor and the smoke was going up. It was an overcast day. No issues traveling down that driveway. Hadn't started raining by the time he got there. Found Todd Stermer laying on the north side of the house. So as you're looking into the house, to the right-hand side, he was badly burned. His skin was slipping off his hands. Defendant was laying on top of him. He described it as face to face. And he had to physically remove the defendant from Todd Stermer's badly burned body. Todd had lacerations to his head and to his back, which you have then the autopsy, a copy of that, as well as pictures. His pants and his underwear were down to his ankles. Had his socks on. Deputy Evans used a plastic, he described it as a plastic molded sled to move his body to a safer location because of that fire, that fuel tank by the house. That was the fuel tank for the furnace. And when he was on the property, That's when he noted a van still running, smoke coming out of the tailpipe, parked in the rear of the residence. And that's when he saw the blood that you have the picture of, and he put a flag on. Tony took several photographs, of which we put several up for you, and they are admitted into evidence. He was able to follow a set of tracks. And he marked them. You can see you've got the left tire here, and you've got the right tire here. See here, you've got the right tire and the left tire. He's able to follow that set of tracks through the area, right through where Todd was originally located. Those tracks led directly to the van that was running. You heard from Deputy Gruss. He was the second deputy to arrive at that Stermer residence. He arrived to the residence fully on fire. You can see by the picture what he saw.
This is a.
He attempted to render aid to Todd.
I still don't know.
He also observed Linda laying on Todd.
I wish I knew about the time limit.
He also stated he saw Linda's hands on Todd's face. He assisted in moving Todd.
Tell him 2 hours.
And performing that aid on his badly burned body. He had an opportunity to speak to Linda Stermer, the defendant. Her statements at that time, where she was downstairs doing the laundry, heard Todd yelling and screaming, ran upstairs to the main level, and it was full of smoke. She was yelling for Todd. She tried to go up the stairway, but could not get through the fire. So she ran out the front door. Later, she saw. You then heard from Dr. Musali. He testified that he was one of the neighbor to the Stermer residence. He saw the fire and he drove to the residence. I believe he said him and his sons were outside doing some chores. They got in a car, drove down to County Road 215 and drove up the driveway. He also discovered Todd in a badly burned state. Todd was laying near the house. He also said Linda was laying on Todd. And he helped move Todd in what he described as a small plastic John boat. And he also attempted to perform aid on Todd. You heard from Annette Crandall, a friend of the Stermers who responded to the scene as soon as she saw the fire. She sat with Linda at that scene, and she then said that she talked to Linda days after the fire, and Linda had told her that she picked Todd up and leaned him against the front bumper, and that's why there was blood on the van. You heard from Steve Leach, also a neighbor of the Stermers. Saw the fire, drove to the residence, lives right by it. He also described how badly burned Todd was. He also talked about how Linda had to forcibly be removed from Todd, not once, but on 2 separate occasions. He talked about how he attempted to render aid to Todd's badly burned body.
Hey, Terry.
He talked about how he helped move Todd away. And he stated, actually, he was the Lawrence fire chief at the time, that he smelled fuel about Todd's person. You then heard from Mike Matheny, the direct neighbor to the Stermers. He testified that he was leaving his residence around 3:30. He went bowling at 4 o'clock on Sundays. He drove to the Stermer residence, and this is key. When he drove into the residence, he saw Linda in the van in the driveway. So we've put up a drawing here. You're coming in this way towards the house. He's coming towards the house, and he sees Linda in this area. And he says, as he's driving down the driveway, what does he see? He sees her back up the van and immediately back of the house. He stated he parked his own vehicle, went down behind where he saw the van going, and shortly after, as he's approaching, he sees Linda out of the van, walking away from the van. He kept asking for Todd's location. Where's Todd? Where's he at? And Linda finally said, there he is. Todd was unclothed when he saw him. He ran to his vehicle to gather some clothing to cover Todd. He talked about just grabbing some of his items that he had, some hoodies, some coats, of which then you'll also see physically. You have the physical evidence of it, and it's talked about in lab reports. He helped move Todd away as well from that location by the fuel tank. You heard from Connie Calhoun in her emotional state. She also testified, she was living with Mike Matheny at the time, that they had bowling on Sunday at 4, and she left about 3:30 out of their residence. And when they were leaving, they saw the smoke when they left their house. She testified that she drove up that same driveway as a passenger in that vehicle with Mike Matheny, and she saw Linda in the van. She stated Linda's van was facing out towards the road. As they're driving down, Linda's driving out, they're facing each other. She then stated Linda's van then turned around and went to the back of the house. She got out of the vehicle, and the next time she went up, she saw Linda laying on Todd. You heard from Kim Thompson. Kim arrived at the scene of the fire. She's a friend and a neighbor to the Stermer family. She was just trying to go and help. She saw Linda for the first time that day on the hill on the north side of the house. Both the family dogs were outside. I think she told you about how they had to try to help catch the dogs a couple different times, at least one of the dogs. Linda told her that she heard Todd yell, "The house is on fire." Then Linda opened the door, opened that basement door at the top of the stairs, and went outside, and she didn't know where Todd was. Another story that Linda told Kim was that there was a kerosene heater located near where Todd's chair was in the living room. In a third story, Linda claimed that Todd may have fallen asleep and dropped his roach. She told you that she took possession of both of those dogs and cared for them after the fire. You then heard from Ken Thompson, her husband. He remembers it being an unusually nice day for that time frame in January. He'd been out cutting wood across the street. spent most of the day there. He had gone past the Stermer residence 15 or 20 minutes before on his way home after cutting wood. Said he didn't notice anything out of the ordinary. Got home, heard about the fire on the scanner, and he immediately got in his car and went back to the Stermer residence. Todd was on the north side of the house when he arrived, and he again described the injuries that he saw. Linda told him that she was downstairs doing laundry, looked up the stairwell and saw fire, too much fire to go upstairs, and she ran out the basement door. You heard Dr. Michael Markey, the forensic pathologist. He talked about how when he received the body, that Todd's body had the socks, the two socks, the underwear, and a shirt across the groin. And that's in the report and detailed in the report. He preserved those items and turned them over to law enforcement. He, as a doctor who does autopsies, had no opinion as to how the blunt force injuries occurred, other than Todd received blunt force trauma. And he described what he looked for and why he made that determination, and how he looked for particular patterns and didn't see them. And so all he could say was a blunt force trauma where the skin splits. Didn't know if the injuries happened before the fire, after the fire, or what caused them. He also couldn't tell the order of the injuries, just based on the body and looking at the body and examining the body. Couldn't tell what injury occurred first. He said that the burns to Todd would have caused severe pain. And that's common sense. When your skin is slipping off your body, that it would be painful. He also talked about the toxicology, which is on this bottom area here. Oops, sorry about that. He talked about the toxicology and about how in the blood they found caffeine, and it was negative for other substances that they screened for. And then in the urine, he found the hydrocodone, hydromorphone, and it was negative for anything else they screened for. And what's important to remember is he couldn't quantify the amounts. He could only tell you that they were above the amount that they screened for. We don't know how much of that drug was in the body. He also talked about 4 distinct lacerations in the head. He talked about one on each side, one on the top, and one in the back. And that's also in his report. He did say, upon questioning, and agreed that it would be consistent with injuries from being hit by a van. And he also said that the lacerations would be consistent with being hit by a blunt force object like a frying pan. He gave the first detailed interview, or conducted the first detailed interview with Ms. Stermer about the fire. We talked a lot in voir dire about what do you do when you have inconsistencies? How do you get to the truth? What do? You start asking more questions. We talked about it in voir dire. Those were the answers you gave me. I ask more questions. It helps me get to the truth. One juror in voir dire, I asked a specific question about, well, what do you find when you start asking more questions? Their answer was, well, sometimes you get blame shifting. Sometimes you get blame shifting. Mr. Shinsky conducted detailed questions, started to dig into the inconsistencies. Linda discusses the morning of the fire, and she gives details about seeing that fire and events that lead up to that fire. And there is a transcript of the interview that you have, the entire transcript to review while you're deliberating. This is where she begins to point blame at Todd. I'm not going to bore you with the entire transcript, but I am going to give you a 2-minute recitation of the high points. Filled up the blazer, came home, he got up. She gave him receipts. He got angry and was screaming at her. Went downstairs and woke up boys, told them to go to the mall because her and Todd needed to talk. Went upstairs and made Todd breakfast. He ate and took meds, and they didn't discuss much more. He sat down and started watching hunting program in the living room. She did some laundry and some dishes, came upstairs and read an acne instruction booklet. Must have fallen asleep. When she got up, Todd asked for juice. She took him more medication. I told him I was going downstairs to do laundry. Todd was yelling at me. And then all of a sudden she heard him scream. She went running upstairs. There was fire from our bedroom to his recliner. He was on fire, his whole upper body, and there was fire and smoke. I just turned and ran out the door. She jumped in the van to go to Mike and Connie's. She backed up and saw Todd in the yard. She got out to try to help and get fire off of him. Later in the interview, he was screaming. We had been arguing quite a bit. We were arguing over me leaving to go to my sister's. Told the boys we were going to be talking about a lot of things. She didn't know how much arguing or yelling Todd was going to want to do. Just asked them if they would just go, and I would let Dad know that they were going. They didn't come up and talk to Todd because he was all angry. Todd was taking prescription meds, her sleeping pills, muscle relaxants, pain pills, a lot of things lately, and smoking pot too. Further, Todd took meds, began watching hunting. She went down and did laundry, folded laundry, and was putting Christmas ornaments in boxes, was puttering, went back up, read acne med pamphlet, dozed off, heard Todd in the basement. When she got up, he was back in the recliner, asked her for something to drink. Got him something to drink, did dishes. When she came up, made him a fire. Todd yelled at me once during the day and told me nobody else would ever have me. Now, when you came upstairs, you said you could hear him yelling, this is Shinsky, and then it turned to screaming. What was the yelling? She said, that's when he was yelling at me that nobody else would ever have me. When she came upstairs, around the corner from the stairway to the living room, there was a lot of fire between our bedroom door and his recliner. Todd was closer to the bedroom. There was just fire and a lot of smoke. There was no fire on the kitchen and dining room side. She could see Todd's legs. The chair was on fire. There was a little fire on the floor. A lot of fire over by the bedroom. She ran out the front door. She doesn't know where he came out. When he came out, he was completely covered in fire. When she came out, it was just black. She ran towards the side of the house. She saw a bunch of smoke. She ran to the van. She backed up and saw Todd. So she pulled forward real quick and jumped out to see if she could help him. He wouldn't lay down. He was trying to pull his pants and his socks off. She screamed at him to lay down. She got back in the van. She couldn't get the van back up because it's so muddy. Pulled over to try to help him. Realized she couldn't and she had to get some help. Jumped back in the van, but couldn't get back up. Usually we go down to the driveway because it's real safe, the house, going real fast. But I was laying on him. I was trying to keep his mouth open and keep him breathing. They pulled me away from Todd. Later, recliner was all on fire. Big bunch of fire by bedroom door in between bedroom and fireplace. Bunch of fire by the recliner. Not much fire in between. Ran out to van, parked in front. The keys were always in the vehicles. Todd does. She always brings hers in and puts in the kitchen. Todd was in the side yard. She pulled the van up real quick and jumped out. She was screaming at him to lay down. He was trying to get his pants off. She kept trying to get up and reach and grab him, his pants. He wouldn't stay still. Then he laid down. She jumped back in the van and tried to back up. She couldn't back up because it was too muddy. Couldn't see Todd when she backed up. Pulled down here because I was going to try and back up to get a running start, and she couldn't. Jumped out, ran to Todd. He was laying. She just laid on him, laid on Todd, trying to keep his airway open. She could tell he was breathing. She ran up almost to the fireplace, and fire came from our bedroom direction towards me, towards the fireplace. So it wasn't the fireplace. Her words. So it wasn't the fireplace. He could not have had fuel on him. I took him juice. I would have smelled it. Oh, since last winter was the last time we used kerosene. You think smoking's the cause of the fire? No, definitely not. We don't even own ashtrays. The kids were everything to him. This is where she begins to blame Todd. This interview greatly differs from the one that she gives Steve Willison 1 month later. Mr. Willison was the attorney hired by Farm Bureau Insurance. He conducted what's called an examination under oath of Linda Stermer. The interviews were conducted in February of 2007, 1 month after the fire, and then again in October. Many statements blame Todd for the trouble, more blame shifting. Stories are more elaborate and more dramatic. These statements also greatly differ. Let's look at the February interview. Finances were the wedge. Todd not running his business as well as he could. And she felt he should work more. He was not putting in enough effort, in debt continuously. What other issues were in the marriage, he asked. Horses. Had 49 at one time during the marriage. Said he was addicted to sleeping pills. Saw him take one the night before the fire. What was it? Ambien CR. Night before the fire, he came in the bedroom and tried to pry her legs apart and take off her pants, but she wouldn't let him. Said if he tried to make her, she'd call the police. Got home that day and began cooking and put on coffee for Todd. Told him that I didn't have any money to get any of this stuff when she got back from the gas station. You wanted me to take care of these things, but I didn't have any money. So I used your debit card again. Spent a total of about 50 to 60. That night, she went downstairs to the basement the night before the fire. The boys were watching TV. She laid on the couch with Trenton and fell asleep. They snuggled because they're a snuggly family. She said she spent the night in the basement the night before the fire. That's when Willison asks, well, what about him forcing himself on you the night before? And she says, that was later, after the kids had gone to bed, and then I went up to brush my teeth. He wanted to talk some more then. I told him no, and I went back down to the basement, and I slept on the couch. She tells Willison she told the boys to call before they came home because she needed to get the blazer for them, and she didn't know where she would be. She told the boys to call her. before she came home. She had to pack. She went back upstairs and gave Todd breakfast. She made plenty of food, but didn't want the boys to eat there because of the way Todd was yelling at her. Told them to leave through the basement sliding doors. Willison says, so he tries to force himself on you and then you get up and get groceries for him and make him breakfast? She says, I thought I was making for everybody.
What?
Then she goes down to the basement. She packs up Christmas ornaments. She does the dishes. She says now for the first time she begins to pack a suitcase. She went upstairs to get things out of the bedroom, and that's when she sees Corey's booklet about acne medication. She reads the booklet and falls asleep. She gets up, comes out. Todd asks for juice. She gets him juice, goes back downstairs. When I went back down, he was screaming at me again. He screamed that no one else would ever have me. And so what did she do? She slammed the door in the laundry room. She's taking the laundry out, and that's when she hears a scream, and she runs upstairs and sees the fire. She says, I saw Todd take 2 Ambien last night. After she gets juice, Todd's ranting upstairs, and then it turned into a scream of pain. She looked in the living room. She sees Todd on fire. Fire was on both sides of him, was on the floor over here to his chair. But he was wearing sweatpants. I know he had socks on. I remember seeing his gray sweatpants. I just screamed and ran. I've got to get out of here. She jumped in the van to drive to the neighbors. What did you do when you got in the van and backed up? She said, I backed up straight. Where did you see Todd? And she marks the X of where she sees Todd when she first gets in the van. She's in the van and marked an X of where she sees Todd. When she sees Todd at that X, he was on fire. She was in the van facing the front door. She did not see where Todd came out. She was going to turn around, but backed up. She didn't back up very far, and that's when she saw Todd. So she pulled up and stopped the van at number 3, which I believe Mr. Willison said she originally marked this number 3, crossed it off, and then wrote the one on top. So she pulled back up after she sees Todd, stops at number 3. I drove up there real fast. I jumped out at number 3 and screamed to just lay down. He was screaming and trying to pull his clothes off. I tried to get close to him. He was jumping and moving. He wouldn't lay down. I was afraid to touch him. So she jumped back in the van and she couldn't get it to go backwards. So I slammed it into gear and I went forward and I almost ran through the fence. And that's what she's marked, ladies and gentlemen, as number 4. So the fence, you recall, is on the side of the property. And I believe you have a drawing showing how many feet that fence is from the house when they did the overhead. Now she almost hits the fence. I almost ran through the fence. I thought if I could get down, because every time we've ever had a hard time anywhere in this driveway, we just come down here because it was sandy and better traction. She could floor it and get back up and get to the neighbors. She got to number 5, which was here. Number 5, so she moved to 5. So she's at the fence, moves to number 5. And that's when she decided she needed to go behind the house. Then she hurried and drove to 6, which is behind the house, and saw Todd. He was not on fire. She ran to him. He didn't have his clothes on and was badly burned. He was like pink melt. She ran to him. When she was close, she saw Mike and Connie. She was screaming and she laid on top of him. She was laying on him because he was naked, and I didn't want him to not be able to breathe. She said, I could feel his heart beating, I could tell he was breathing, but it was hard for him. So I put my mouth on his mouth a few times and I just tried to give him little breaths. She saw Todd's skin was melted. She threw her purse in the van while she was talking to the boys as they were leaving. She talked to them on the way out because she had turned water on in the horse tank, told them to hang on a minute, not to take off without her purse, went out the basement door with them, put purse in the van because she thought she'd be leaving in the van. The fire was not connected to the fireplace. That's February.
All the boys said they went upstairs and went out front, right?
October is a small pack. October had already received $93,000 and $96,000. What was the issue you needed to get away from? His lack of working as much as I thought he should be working, getting behind in the bills. You described pretty heavy fighting Saturday night. She says, I don't recall that it was heavy fighting. I know we argued some. Well, Wilson says, didn't he try to rape you? No one ever have me. Then he let out a terrible scream. She ran around the corner of the living room. Todd was on fire. Fire went from Todd to the bedroom. Got in the car, thought she was going to the neighbors to get help. She went through the yard by the barbed wire fence. She couldn't get going and get out of that spot, so she needed to pull down the hill to where there was better traction. She saw Todd before she got to the barbed wire, pulled away from the fence a little and got stuck. When she puts Van in forward, she knows Todd's outside. She pulled forward down to the bottom by the house, by the slider. She was going to turn around and come back up the hill, going to try to barrel back up the hill, but sees Todd. First time she saw anyone other than Todd was at the bottom of the hill, either running to Todd or still in the van. She saw Mike and Connie at the top of the hill. She remembers backing up and seeing Todd outside. Got out of the van, screaming at him to lay down. He wouldn't lay down. He was trying to take his clothes off. He wouldn't listen. So then she gets back in the van, floored it too hard. She went too far off the driveway, stopped at the bottom and didn't turn around and came back up because she saw him laying on the ground. She ran to him. She saw the neighbors there. He didn't talk, but he was moving his mouth. He was still alive. He was having a hard time breathing. She remembered breathing into him a few times. They lifted her away. That was October. There's multiple inconsistencies, some consistencies. There's many different statements that blame Todd and point to this blame shifting. The stories are more elaborate, and the statements differ from the ones given to Shinsky. You then heard from David Hayhurst. He's from the Michigan State Police Crime Lab, and he conducted the examination of the van belonging to Todd Stermer. He noted that there were several red-brown stains on the front bumper and the underside of the van. He actually took samples, L1 through L6, of 6 different locations on that van. Said started from the front and went towards the back. All of the locations were then on the driver's side, and they were all on the front-facing parts of the vehicle as he went back. He took samples from all those stains, and he determined them, after testing, to be human blood. You then heard from Ann Hunt, who took those samples and tested a few of them. They're in the report of which one she tested, the locations that they came from, and they matched the DNA from the DNA card taken at the autopsy of Todd Stermer. You then heard from Troy Ernst. He tested the socks, the underwear, the sweatpants, the shirt across Todd's groin area that went into the body bag. And what did he find? Those tested positive for gasoline. He also tested all of the other clothing that you heard from testimony that was placed on Todd. That was Mr. McTheney's. That was put into a separate bag. I believe Detective Misiowski talked about a clean garbage bag. He tested those items, and those are in his report, and those tested negative for the presence of gasoline. And when I asked him about would it be more likely from one of those to then transfer to the other, he said that due to the nature of the particles on the sweatpants, the socks, the sweatpants, the socks, and the underwear, and the difference in the testing that he had done, I believe he described it as lighter and heavier particles, that it would be more likely the transference would have happened in the body bag from the sweatpants, socks, and underwear to the shirt, based on his testing of those particles. He was not able to quantify how much gas was on any of these items. He could only tell us that there was gas, the presence of gas. And he also told us that there was the presence of gas in that gas can, which he also tested. You heard testimony from Detective Rout. She was the detective called to the Stermer residence that evening of the fire. And she also took statements from Linda the night of the fire. Linda talked of an argument that occurred that morning of the fire. She detailed that the argument was over finances and her using a debit card. She had the boys leave to go to the mall so they wouldn't hear arguing, and said no further arguing occurred after the boys left the house. After the boys left, she went outside to turn on water for the horses. She went into the bedroom while Todd was watching TV to read acne pamphlet. Todd was watching TV and she was going to read the acne pamphlet and fall asleep. Woke up, Todd asked her for juice, of which she brought him. She then stated that Linda went downstairs to do the laundry, let out both the dogs and the cat. Not sure where the cat was or why she remembered a cat. Straightened up a bathroom, was in a laundry room and heard Todd scream that there was a fire, ran upstairs, saw a fire in the living room and a lot of smoke, but could not see Todd. And she left the residence, got in the van, heard a boom, and saw Todd on fire on the north side of the residence. Todd was on fire trying to shed his clothes. Then she stated she lost sight of Todd and drove around the north side of the residence to the west side near the basement to either get help or get Todd into the van. Todd was on fire. He wouldn't stop moving. She denied that she ever grabbed Todd. He was burned and gasping, and she was trying to keep his mouth open. Eventually, Connie, Mike, and Dr. Musali arrived, and she stated that there was a fire going in the fireplace. Detective Tom Misiowski testified. He was also another detective called on. He arrived, he observed the person of Todd Stermer. He noticed the significant burns and the lacerations to his head. He also noted that Todd's person smelled of fuel. He collected the clothing taken off of Todd, and he attended the autopsy and also collected those items. Remember, the item that Sergeant Leroy collected are the sweatpants. Detective Misiowski collected the other evidence. Detective Misiowski was also present at the execution of the search warrant of the van. This was January 9th, 2 days later. He observed several possible blood stains on the driver's side of the van, consistently on the driver's side as you're going from front to back of the van. Saw no signs on the van, and you'll have the pictures of the van as well, that the van was ever stuck in the yard or that the van had become stuck. And when he looked at the tire ruts, the tire tracks, also didn't see any evidence of that. He did take a picture and saw the purse in the van that had Linda Stermer's wallet in it for identification. He determined it to be her purse, and he found $202 in cash.
That's not going to get you very far these days. Oh, wait, that was 18 years ago. Never mind.
Scott Leroy was the expert witness in the fire investigation. He was called in to determine the cause and the origin of fire at the Stermer residence. He collected these sweatpants that you see at Todd's ankles, as well as the socks and the underwear. He took photographs of some photographs of the Stermer residence that night, more later. And there was no examination of the house because it was still smoldering. It was the night of the fire. So he didn't go into the house due to safety concerns on January 7th. As he's removing the sweatpants, he's smelling accelerants. He went on January 8th to the Stermer residence, and that's when he took several photographs of the Stermer residence. I believe he went around the house, and you have those photos. He examined each room of the house to determine the area of origin for the fire as he's going around the home. And you can see the gas can that was found the next day. It was also shown in pictures the night before. With all the data that Sergeant Leroy has, he uses it to determine the area of origin. Data of what he's found, data what he sees, the pictures, the data of the statements made by Ms. Stermer. He uses a systematic approach to examine for evidence and determine the area of origin. He explained to you what he did, what his system was. He talked to you about burn patterns and mass loss and about how that was used in the determination. And what he determined that the area of origin was the living room. And later, this was confirmed with the additional statements of Ms. Stermer. This is where he marked the area of origin. He talked about mass loss. He talked about the roof that you still have in place. He talked about the walls still in place. And then he matched them with Ms. Stermer and what she saw. This is where Ms. Stermer saw the fire. You've got the recliner here, and where she described seeing Todd Stermer when she came up the stairs. Matches his origin. He told you how he examined several different possibilities. Any causes that he felt were relevant, he used his common sense, formed his hypotheses at that Stermer residence. He considered the furnace. He ruled it out based on the mass loss, based on the evidence that supported an electrical fire. Electrical fires typically start in the walls. The wall studs, electrical fires take time to burn, time to develop. He also considered the fireplace as a cause of the fire. He looked at the burn pattern evidence and it didn't support a chimney or a fireplace fire. He talked about how those timbers right above the fireplace and a header of raw wood above the fireplace. Those timbers around the fireplace would have completely burned if the fireplace or the chimney were the cause. Would fall on top of the box. He talked about how all of that would burn. And he talked about how fire consumes everything in that little area of origin that it's working on. And then as it exhausts its fuel, it burns out and up. It would have burned everything around it before it moved. He also stated that there would have been a lot of smoke expected in a chimney fire, and that would have been probably noticed by able-bodied adults.
She looks like she's falling asleep to me.
Other possible causes were also considered and eliminated. He looked at the fuel oil lamps. They were small. They would have been a very small fire. They weren't consistent with gasoline or a description of the fire from Linda. And per Linda, the fire was not in the dining room or the kitchen, which is where those oil lamps were. He also considered a log rolling out. Talked about how there'd be a slow, smoldering fire, would not have spread quickly, and would have probably been noticed by Todd. He looked at if this was an intentionally set fire. He considered the fact that there's gasoline present in the area of origin with no explanation of why gasoline would be present there. Todd is found with gas on his sweatpants, socks, and underwear. He's on fire in the living room. Why is there gasoline there? It's a sudden fire, described as Linda. She talks about how he was yelling at her and then it immediately turned to screams. Not the description of a small, smoldering fire. She talks about the fire in between, extending from one side of the living room to the other. She talks about how it goes from the bedroom to the recliner, almost as if it's a trail of fire between the two. All of these, ladies and gentlemen, are consistent with an intentionally set fire. Common sense. Now let's look at what Cynthia DeLoach said. Cynthia DeLoach remembers January 7 of 2007 because it's a small town. She worked that day. She thought her mom's house might be on fire. They drove out there. It was a big deal in their small community. She remembers distinctly Ms. Stermer came to the Marathon gas station approximately 9 a.m. that day. She explained on the receipt the time was off by an hour. Her boss had never adjusted for the time change. She stated Linda purchased gasoline with Todd Stermer's credit card at pump 3. You can see she described the account numbers match on the receipts. Here and here. This is the outdoor. She specifically remembered the fuel hose going into the back hatch of Linda's Blazer. And I think she actually described it. She said, you know, when you have the glass half and you turn the latch and you lift it up. And she specifically remembers the hose going into the back underneath that glass hatch. Like if she was filling up a gas can. She did say, I stopped watching after that. After I saw that, I just figured she was filling up a gas can, went about her business. Didn't see then what happened. Didn't see if maybe then she did put it in her gas can or in her car. She didn't know. But she does remember clearly the hose going into the back of the vehicle. You heard from Brad Stermer, Todd's brother. He helped Todd build on several pieces of the residence. He described Todd as a physically fit and a very capable person, very capable man. Todd loved his house. In the driveway of the house, he said it was a path when they were using it in the beginning of it, when they started it, they used it as a path for construction. But after that, Todd graded it into a yard. So after construction was done, they stopped using it, and that's when he graded it and did the final grade. Todd and Linda, he also testified, were in poor financial condition at the time, and he stated that the horses were a financial strain on the marriage. Linda told him, I'm sorry, I can't read the small print, that on January 9th, Linda told him on January 9th, 2007, Linda described to him that she was downstairs doing laundry and heard Todd yell, "Linda." She ran upstairs, she did not see Todd, and she ran out of the house. When he found inconsistencies and questioned her further, that's when he said, well, what about the smoke detectors? Didn't they go off? He knew that he had helped do all the hard wiring for those smoke detectors. And that's when she said, oh, we were having issues with them. Todd disconnected them. And then she didn't want to talk anymore. You heard from Mr. Chris Williams. You heard that he started an extramarital affair with Linda before the fire. About 6 months before the fire, they met at work. He talked about how she pursued him. Showed up at a parking lot one time when he was there shopping. He said he had sex with Linda about twice a week for 6 to 8 months, right in that time frame. Most encounters occurred at his house in Kalamazoo. He talked about how once they did go to see some museums or something in Grand Rapids, and they did some joyriding together, riding around in the car, but mostly it was just meeting up at his house. He said they did try to keep it quiet at work, and he knew she was married. That's why they tried to keep it quiet. He said that he saw a different side of Linda that Friday before the fire when Todd had sold a truck to purchase a van. That's when he saw a different side of her. He also testified from a question that Linda took him to the fire scene months and months later after all the debris had been removed. We don't know why, but he testified she took him there. You heard from Kathy Ill. Met Linda in 2006. After the fire, she was at the Stermer residence. She noted several school pictures of the boys stacked in frames out in the shed. Linda also told her she needed to look for a cup in the dishwasher, and she wanted to look for some rings in the house. Ms. Ill got into Linda's vehicle later, and she noted a lot of jewelry in the center console area of the vehicle. You also heard from Kate Fox. They both had kids in Lawrence schools. They started work together at ChemLink. They became best friends. They actually carpooled to work together almost every day. Linda, in those car rides, began to confide to her with problems in her marriage. She started claiming abuse. Kate testified she never saw any signs of abuse. She did tell Kate about her affair with Chris Williams and that she wanted to be with Mr. Williams. The defendant wanted to be with Mr. Williams. She said he was the best lover she had ever had. And Linda told her about wanting a divorce from Todd. Kate drove Linda to Chris Williams's house on several occasions and actually told the police where he lived. Gave them the information of how to contact him. She testified that she knew Linda had 2 phones. One was kept at her house so Todd could not find it. Sometimes it was kept under the dash of the Blazer. She also talked a lot about how the defendant would talk to Chris Williams on the car rides home. She told Kate she thought of several ways to get rid of her husband. She told Kate that she considered shooting him, and she told Kate that she considered running him over with a car. She also testified that she called the police on Thanksgiving, just 6-8 weeks before the fire, because Linda had a gun and said, "Give me one good reason why I should not shoot Todd." She called the police because she feared for Todd. She said Todd was suspicious of Linda 2 to 3 weeks before the fire because he discovered a secret post office box. She asked Kate to go and clean it out. Clean out that post office box, get everything out of it. She also told Kate that Kate said Linda told her that she ran over Todd. She said one story, it was because it was smoky and she couldn't see Todd and she accidentally hit him. And then she said the second version is that Todd ran out in front of him and then she struck him. She also said Linda called her a few days after the fire, in the dishwasher of the burned home that contained tranquilizers that she was planning to give to Todd. This is when she decided to have Kathy Ilg reach out to the police. And she wanted it to appear that the police were coming to her, not that she was going to them. She didn't want to walk into the police station. She didn't want to make a call. She didn't want any report saying Kate Fox called the police. She wanted it to look like the police came to her. You then heard the testimony of Dardita Gordon. Dardita is the unavailable witness. She has since passed away since her sworn testimony. Her testimony stated that she was housed in a jail cell with Linda and that she befriended her. And Linda stated Todd was on medication. She testified to that. And she stated Linda told her she hit Todd with an object during an argument and started the fire. She didn't say what the object was. Even when pressed, she didn't say what the object was. She said it was just an object. And she stated that she started the fire with gasoline. You heard from Corey Pierce, the nephew raised as a son by Todd and Linda. You heard downstairs. He said Linda did not come downstairs that night. He did not hear his father working on the furnace, and his bedroom shared a wall with the furnace room. He says the day of the fire, he woke up to an argument between Todd and Linda about cheating. Linda came down and sat on the bed and said the boys needed to leave so that her and Todd could split up property for a divorce. Told him to take his brothers to Kalamazoo. And she told him she wanted Todd to think the boys were still home so that they would argue less. The day of the fire, Corey testified that he went upstairs, he saw Todd sitting in the living room, saw his arm, but he didn't see his face. He testified that Linda blocked one of his brothers from going to see Todd. He testified it was always common practice to give a hug and a kiss and say, "I love you," before leaving the house anytime. He specifically remembered seeing Linda's purse on the kitchen counter when he walked straight up the stairs. He said Linda told him that there were some statements about what had occurred in the fire, and those conversations usually happened in the vehicle with his brothers after the fire. He said one version, there was too much smoke when she tried to get up the stairs, and that she ran out the basement. Another version was that she ran upstairs and saw Todd on fire and ran to get help. When the brothers would question her differing events, like we talked about in voir dire, confronting with conflicting statements, that's when she would yell and become physically violent. He stated Linda coached him and his brothers on what to say prior to any interview or testimony, and said if they didn't listen, they didn't listen to her instructions, that they wouldn't receive any insurance payout to replace their things that they had lost in the fire. You heard from Trenton, the youngest. He was 12 at the time of the fire. He remembers an argument the night before. He stated Linda did not come down in the basement the night before the fire to watch TV or to cuddle with him. And he ready, they went up the stairs. He stated Linda blocked him from seeing Todd. It seemed like Todd was sleeping, but she shooed them out of the house. They left the residence in the black Blazer. He said that when Linda talked to them about what happened, there were differing stories. One version was she couldn't get upstairs and that she exited out the basement. One version was that if she could get upstairs and then she exited out the front door. He said Linda would attack him if he confronted her with her changing stories. He stated Linda gave him a bloody nose on one occasion and when instructed his brother Trevor, the older brother, to silence him when he started questioning and pushing. Linda told him to say, "I don't remember," to certain questions during the insurance investigation. Lastly, you heard from Trevor. He said that the Stermer home was about 95% complete. They were missing some floor coverings, but he said about 95%. He said there were working smoke detectors, and he actually talked to you about how they would beep and he'd have to replace the batteries. He said Todd was meticulous about safety. He said the night before the fire, there was a very heated argument. It was the worst one he'd ever heard. He was asked to leave his brand new bedroom in that loft and go stay downstairs with his brothers because of the severity of the argument. Also had an open loft area, so probably was for the noise as well. She told him he talked about why they were arguing. He said it started with finances related to Linda's horses, and then it transitioned into Linda's infidelities. He also said Linda did not stay in the basement on the couch or cuddle with any of them that night. And Todd did not come downstairs that night. He said on January 7th of 2007, he woke up at 8 a.m. He tried to go upstairs, but Linda stopped him. You remember, he was the first one to wake up. He woke up early and he wanted to get some breakfast. And she stopped him twice from going upstairs. Said another argument broke out that morning. And I think he actually said Linda brought him down a Pop-Tart at one time. Linda asked the boys to leave the house to go to Kalamazoo to a mall and movie. He didn't want to go. He wanted to wake up his dad and make an argument of why he wanted to stay. Tried to speak with Todd twice, just hoping maybe he could just stay home. And both times he was blocked by Linda from going to talk to his father. He said after the fire, Linda's stories changed each time. What door she exited would change. She'd get angry and attack his brothers, or direct him to attack Trenton to stop the questioning of her stories. He said Linda sheltered them from any outside information. He only knew the facts as provided by Linda. He also coached them on what to say when questioned by the insurance or police. He also remembered a duck boat. He remembers Todd having a small plastic duck boat. He said it never had a gasoline engine. It had oars that they would use. And they would take it out in the back pond to go duck hunting on the property. Told a story about how Todd let him spray paint it camouflage with the green and black paint. He also said Linda's horses were an obsession. So let's break it down by the elements. Remember, you, as the jurors, have the opportunity to look at all the evidence. All the evidence surrounding this fire and making your determination on whether this was an arson fire set by Linda Stermer. No one witness is the entire case. You get to judge all of the evidence, and it's your decision. Start out with the second element of arson. We know at the time of the building, they were living there. It was a dwelling. So I've checked the box. Let's look at the evidence that would support the other two. What's the evidence that supports arson? The defendant bought gasoline. Actually, I'm going to stop there for a moment. I'm going to read to you the definition of circumstantial evidence, not in entirety. You'll have the entirety when you go back. Circumstantial evidence is evidence that normally or reasonably leads to other facts. Common sense. The defendant buys gasoline the morning of the fire. She's observed by Cynthia Deloach to have the hose in the rear of her hatch. The only reason would be to be filling a gas can. She's certainly not pumping it into the interior of the car. There's a small 1-gallon gas can found in front of the Stermer residence at the fire. There's no explicable reason for this can to be in this location. You saw a picture of all the gas cans neatly stacked in the shed. All of them, except for this 1 gallon. You heard the testimony about the huge tractor and how they wouldn't use a 1 gallon to fill up the tractor in the backyard. Gasoline is found on Todd's sweatpants, his underwear, and his socks. What leads to a logical progression? Then you can look at Linda's misdirection as evidence of an arson. In any detailed statement, she attempts to redirect towards the fuel oil furnace. She consistently mentions Todd bleeding the furnace the night before the fire. There's no evidence that supports this. As if she's redirecting you to think that that's why he would have fuel oil, which we know now is inconsistent. Fuel oil tests differently from gasoline. Fuel oil is chemically distinct from gasoline, and that's what you heard from the chemist. She tried to claim Todd accidentally started it with a dropped roach. There's no THC found in his system on that autopsy. It's not in his system, it's not in his blood, it's not in his urine. She describes what we call a fire trace. She detailed and described the path going from the recliner to the bedroom where Todd was. She described an excellent trail across her living room. It's like, what else? The suddenness of the fire. Todd went from yelling at her to immediately screaming in pain. You also heard witnesses talking about how within minutes of getting there, it just started to it was consumed. They were watching how it just started breaking through. I think it was Musali's, Matheny's, Thompson's, everybody was talking about how quickly it just was being consumed. This implies that it happened quickly from her statements. 1 minute it's not there, the next minute he's yelling in pain. Now that also we can look at the fact that she ran Todd over as evidence of an arson. He's the only witness to the crime other than her. And after Linda, sorry, your type is very small. After Linda realized he escapes, his survival would have left Todd as a possible witness.
I don't
And
think
she
that's
needed to
evidence of
silence that
arson. I'm
witness.
sorry.
You can also look at supporting arson, that she's laying on Todd, because that supports her intent to silence him. She laid on a man whose skin is sloughing off. They tried to carry him away and they couldn't because his skin was coming off and they had to put him in the boat to move him. She laid on a badly burned man who she described as pink melt and talked about how he was struggling to breathe. Why would you lay on a person with that severe injury and who's struggling to breathe? She had to forcibly be removed from him as they're trying to render aid 2 times. This can all be considered as part of the arson. You can also consider that she let the dogs out moments before the fire erupted. She didn't want her dogs to be killed in the fire. You can also consider that there were framed pictures of her children that were moved to a shed on the property.
You don't know
Precious
when they were moved.
keepsakes were spared, things that can't be replaced. The boys, pictures, the dogs. She didn't have to worry about the horses, they were outside. You as jurors can take the totality of all the evidence presented, all of the evidence presented, supporting that Linda intentionally set that fire. The element, the defendant burned the building. We believe we've given you the evidence. We believe that we've given you everything you need to make that common sense approach. What makes sense and leads to the conclusion? The conclusion is that the defendant burned that building, it was a dwelling, and that she intended to burn it. So let's go to count 1. Let's go to evidence of murder. Actually, it applies to count 1 and count 2. What then gives the support for the details of the murder? The details of the day of the fire are very inconsistent. You can look at her statements. She tells multiple stories about how she exited the residence. She tells multiple stories about what she saw. She tells multiple stories about why there's marital discourse, but denies that she's having an affair. She only gives the details she thinks won't incriminate her. And into the yard, which makes she drives to an area worse off then that incline driveway, the incline driveway that fire trucks are coming down, emergency vehicles are coming down. You saw pictures of it the next day. She drives to an area worse off than the driveway. She drives to an area that's more difficult traction, down a hill. She claims to be trying to get help, yet she drives into the backyard when Mike and Connie are driving down to her. She's in the driveway when they see her. Tracks in the yard show the van going from where Todd was laying in his pool of blood to the backyard. Claims to not know she hit Todd, yet the blood is all on the driver's side. There's a reason we talked about that in voir dire. You guys gave descriptions of what you heard when you hit a squirrel, a raccoon. This is all on the driver's side, and there's 7 points of impact with Todd's blood. She claims she didn't know she hit Todd, yet blood's all over that driver's side. And once she claimed, maybe in an attempt to try to cover her tracks to one person, that she got out and leaned Todd against the bumper of the van, and that's why blood was present, which is interesting because he would have had to have been bloody before she hit him and then leaned him up against the bumper in order for that blood to get there. What else can we look at for evidence that it was a murder? You can look at the evidence that Dardita Gordon gave you in her testimony. Linda admitted to striking him with an object during an altercation. She admitted to starting the fire with gasoline. She knew Todd was on a medication. That's an odd fact for somebody at the jail to know without directly being told by the defendant. Todd suffered multiple lacerations that can easily be explained as a result of being struck by a blunt object. There's one completely in the back of the head.
Yep.
There's one on the top of the head. There's two on the side.
Yeah, she's going too long.
One could easily be explained
She's
by a
going too
blunt
long.
object. Perhaps even the frying pan that you see in the rubble that was not above, there was no kitchen above, and it was found in the laundry room. She admitted to wanting Todd gone. You can consider that evidence. She concocted ways to kill Todd. She thought about running him over and said that to Kate Fox. She thought about shooting him with a gun. That's why Kate called the police. She'd become violent with the boys. You can consider that. When confronted with inconsistencies, she became physically violent with the boys when they pressed on her inconsistencies. She coached the boys on what to say. Why would she have to coach them on what to say? She told them what to say at interviews, told them what to say to the police. She'd only do this. She's trying to hide the truth. Why didn't she just tell them, tell the truth, tell what you know? Why'd she coach them on what they could say? So let's look at evidence of premeditation, because that's count one. You gotta find evidence of premeditation. First thing, purchasing gasoline. You can consider for all these different things. You can consider for the arson, you can also consider it as evidence of premeditation. She gets up in the morning, she buys gasoline the morning of the fire. Cindy sees her, putting the hose in the rear of the hatch. Only logical conclusion, she's filling a gas can. A 1 gallon gas can is found at the front yard at the time of the fire. Tells Kate Fox she wants to kill Todd. She's thinking about it. Differing ways of completing the act. She attempts to frame Todd. Gas. She claims she didn't have any money, which I read to you, which is why she used the debit card, but yet she has $202 in her wallet in cash. Why is she using Todd's credit card? She wanted to look like Todd was the one that bought the gas. She consistently tried to paint Todd in a terrible light. despite having no evidence to support her accusations. Blame shifting. You can consider that as evidence of premeditation. You can also consider that she sent the boys away from home. She's thinking about it. Why did she send them all away? She told them to call first before coming home. She didn't let them see their dad. She physically blocked them from seeing their dad. Keys were waiting for him in the blazer. What else? Her purse. Her purse and her money were found in the van. Corey specifically remembers that purse on the counter when he came up the stairs, said he was looking right at it. Linda was preparing to be gone after that fire started.
I don't think that's what he
That's
said.
the evidence the morning before the fire starts. She sees Todd escape the burning residence. He's screaming, pulling off his clothes, hollering in the yard. She can't let him survive. He's going to tell what happened. So what does she do? She gets in the van. She makes a nice little arc pattern to the north side into the backyard and runs him over. She strikes him on the driver's side, directly in her line of sight. And she tells you multiple times, I saw him in the yard, then I got in the van. She saw him before she got in the van. And what did she do? She drove immediately and drove over him as Mike and Connie are coming up behind. That's the second instance of premeditation. You got the premeditation in the morning about the fire. Now you got the premeditation of trying to run him over when he escapes. But now let's talk about the third time and her attempt to try to silence him when she doesn't kill him after she runs him over.
I can't believe
He's
she hasn't said
breathing.
that she's
His
got
heart
heat
is
over
still
his mouth
beating.
yet.
He's struggling to breathe. His mouth is moving. And what does she do? She jumps on him face to face on his burned body. She places herself on his body, covers his face with her hands by one witness's description.
Oh, there, she heard me.
She has to be forcibly removed by people who are trying to help him and render aid. She knew he was struggling. She knew he was hurting, and she laid on his body. Why? She's thinking about, what if he talks?
Or she's
What if he
thinking, my
lives?
husband is dying. I would go grab Travis.
Judge
Well,
is going to
no,
give you an
I think
instruction. We don't need to prove motive, but it's something you can consider. It's not an element, does not a box, but it's certainly something you can think about. What could be the motive? Well, you got finances, cash strapped, behind on bills. Todd's lazy, doesn't work enough, doesn't make enough money for her. Divorce isn't going to benefit her. At the time, she has multiple horses. Horses are very expensive. Without money, you can't care for them. Without land, you can't care for them. Divorce would have likely have ended up in a place, she wouldn't have had a place to keep her horses. Her obsession. Let's talk about Chris. She has been engaged in a 6-month relationship with a man she wants to be with. Best lover she's ever had. Wants to be with him. It's a long-term affair. Ends up going at least 8 months before she breaks it off with him after the fire. Let's talk about common sense.
there you
I
go.
told you, don't check your common sense at the front door when you come in this courtroom.
Twice.
Let's talk about why the store. She's in. Yet she goes to the store and she makes him breakfast, builds him a fire because he says, hey, it'd be a good day for a fire. Yet gets him juice when he asks. Yet she putters about the house. Yet she puts Christmas decorations away. She reads an acne pamphlet and takes a nap, yet sends her children away from the home and her main source of transportation on the day she's supposed to be moving to her sister's. They're getting ready for such a huge fight. They're splitting up all their assets, send the boys away because this is going to be so horrible. And she's making breakfast and putting Christmas ornaments away and taking a nap and leave. Why did she drive the van in the manner that she did? She claims she drove the van to get help, yet help is coming down the driveway, the very help she said she's getting ready to go get. She's going to get Mike and Connie to help. They're coming down the driveway. Why? Why is she driving to the north side of the house when help, the very help she wants, is coming down the driveway? She claims to not have ever seen Todd in the side yard. Yet she strikes him on the driver's side, going at what we've heard may be slow speeds. She lines up and hits him on the driver's side. She says it was so smoky she couldn't see him in the yard. Look at the smoke, ladies and gentlemen. There's no smoke in the side yard. Certainly not obstructing her view in the side yard to see. You could see the trees in the background. Common sense says if you got outside, you saw your loved one escape that house on fire. Common sense says, yeah, I probably better go and try to help this person because by the time I drive down to the neighbors, how many feet away, this guy's going to be burned up. Common sense, okay, let's say you panic and you don't think that way. Common sense would be like, oh my goodness, my husband, the father of my children is on fire. You'd keep your eyes on him to see what's happening. She says, I see him when he comes out. He's on fire. But then she claims, then she didn't know where he went. Doesn't make any sense. Why she drove onto the backyard? She claims it was to get better traction. Testimony established this was not an improved driveway. You saw the pictures. You can have them back in the jury room with you. Traction in this area is way worse. Going down a hill. Think about your grade, your basement, even if you have an 8-foot ceiling, you're going down 8 feet. Claimed she did this to get to the neighbors, yet the neighbors are already there. So let's talk about what does make sense. What leads from one conclusion to another.
Thank you. I lost track.
The morning of the fire, Ms. Stermer gets up. She's contemplating the fire. She goes, she purchases gasoline, and she removes the things most precious to her from the home. Probably makes sense. She was arguing about her affair with Chris Williams, with Todd. She strikes Todd with an object sometime during that altercation, just like she told Dardita that she struck him during an altercation. And now you've got a possible laceration from blunt force trauma on the head. Dr. Markey testified that you can knock somebody unconscious without having any brain trauma, that just having that indentation, you could knock somebody unconscious.
Well, usually if you lose.
Also makes sense that she had planned to drug Todd with a cup in the dishwasher, but she changed course. Maybe that argument got out of hand. Maybe she just changed her mind and decided this was an easier way. She douses Todd with that gasoline that she bought that morning. So gets it on his underwear, socks, sweatpants, recliner. And he's not on fire yet. She runs downstairs. We don't know. She's changing clothes. She's letting the dogs out. Did she ever run downstairs? We don't know. If she does, we don't know why. Maybe she's changing clothes. She doesn't expect the fire to erupt as quickly as it did because she doesn't know it's the vapors that were testified to that can ignite. You have an incapacitated man with gasoline on him You run downstairs to grab something, do whatever you're doing, those vapors ignite. It would explain why it's sudden. It would explain why it catches her off. She planned on throwing in a match. It just happened too quick. Those vapors ignited. You've got that open source of flame, that fireplace, and it just erupted before she's ready. She flees the house. Here's the top of the stairs, as she describes it, and as Corey describes it.
That's
She
reasonable
gets to the
doubt,
top
right?
of the stairs, there's the counter, right where her purse is, right where Corey described it. She grabs her purse in an attempt to escape. Maybe she thinks she can just get in the van and drive away. He'll burn up. She'll have an alibi. She's not at the house. So she's going to drive away. Problem is, Todd escapes. She sees Todd. He's in the side yard, ripping off his clothes, screaming. At that point, she's thinking, he's alive. Got to be silenced. What does make sense? She's trying to flee. Now she really panics. She can't leave this burning man in the north side of the yard, hoping he's just going to die and she could drive away. Now she's been caught. She's been caught by Mike and Connie. What's she going to do? Is she going to take the chance that he's getting that fire out? I'm going to tell Mike and Connie what happened. She panics. She pulls off the driveway into the rear yard. She lines Todd up with the driver's side and she runs him over. And I want you to think about relating that to all the stories she told Willison and Shinsky. Those are so elaborate. Driving, getting out, trying to help. He won't lay down. I get back in the van. I then drive, then I get stuck. Didn't happen. No time. Connie and Mike saw her right in the driveway. There was no time for any of her elaborate story to occur. There's no time. What does make sense? Todd gets out of the house on fire. She runs him over. She runs over to him. Oh my gosh, he's still alive. He's breathing. His mouth is moving. Now what do I do? I'll tell you what she did. She made another attempt to silence him. She jumps on a man who is struggling to breathe, placing her hands over his mouth. In yet her third attempt to make sure he can't talk and tell what happens. Using your common sense, that makes sense. The facts as told by Ms. Stermer make no sense.
Yeah, she's going too long. She needs to
Then you often look at the cover up.
work on whittling down her closing.
She tells multiple half-truths. We talked about half-truths in voir dire. We talked about what you do when you have a half-truth. She gives half-truths about the events of the day. She gives multiple versions of the events. She changes details surrounding the cause of the argument. She can't even keep straight what door she goes out of. She becomes physically violent or emotional when she's confronted with inconsistencies. She coaches her sons on what to say. More questions lead to differing stories. This is because, ladies and gentlemen, she can't tell the truth of what happened on January 7th of 2007. Because the truth makes her guilty of premeditating that murder, of trying to kill him in an arson, and ultimately his death. She wanted to make sure Todd was dead that day, and she wanted to make sure she did everything possible to make sure he did not survive. He didn't survive the house. He didn't survive the van. And he didn't survive even laying on that ground. She did whatever she could. Ladies and gentlemen, common sense. These boxes are checked. Linda Stermer caused the death of Todd Stermer. She intended to kill Todd Stermer. Her intent to kill was premeditated. You have all kinds of evidence of that. And that killing was deliberate, meaning she thought about it, she weighed the pros and cons, and she made multiple actions, confirming that that was her intent. She had time to think about it and change her mind. She didn't. She caused the death of Todd Stermer. She had one of those three states of mind. She either intended to kill him, intended to do great bodily harm, this is count 2, or she knowingly created a very high risk of death, knowing that that death would likely be the result of her actions. And that when she did that act, when she caused the death of Todd Stermer, she was committing or attempting to commit arson. Those are your elements. Ladies and gentlemen, common sense tells you those boxes are checked. You have all of the evidence. You have everything for that logical conclusion. I'm asking you, ladies and gentlemen, to go back into that jury room, go through that evidence in more detail that I've given you. I've given you a snippet over the 3 weeks that you've been here. I tried to sum it up for you. You have more. You can review anything you want back in that jury room. Look at that evidence, piece it to those boxes, and I'm asking you to find Linda Stermer guilty of both count 1, premeditated murder, and count 2, felony murder during the commission of the arson. I appreciate all your time and attention. Thank you.
Mr. Mueller?
Thank you, Anna. Give me just a second for a little housekeeping.
Here we go.
Yes, thank you.
Oh, we're playing Pictionary again. Yay. Dang, that was a long closing. I guess she's not timing them. They usually get an hour apiece. That's not in this court. Not surprised since the woman doesn't control her courtroom. Man, I still don't know. That's all circumstantial, and it makes her look. It doesn't mean she is. It's not proof. It's no reasonable doubt.
Ms. Sitterby?
Even stuff she said in the closing was reasonable doubt. It could have been this. It could have been that. That reasonable doubt in her closing. Oh, they know what voir dire is. That's when she talked to them.
Closing argument. So we'll make it the usual, about 15 minutes, directly to the jury room. Remember your rules.
Why? Voir dire is what it's called when they're picking a jury. So they ask them questions in voir dire. And so a lot of time during openings and closings, they'll say, remember back in voir dire when I asked you such and such? So they know what voir dire means. I don't know what it means in Latin, though. Does anybody know what it means in Latin?
Council, any matters to address in our break?
No, Your Honor.
No,
Okay,
Oh, we're just
What
taking a
time?
break. Okay.
2:30-ish. I told him about 15 minutes, 2:35.
I thought Mueller wanted a break, a bench conference or something. I was like, why are we doing that now? They're just taking a break. Okay. Let me look up and see what voir dire means in Latin. I don't know what that word means in Latin. I'm not sure how to spell it. To speak the truth. It refers to a process of determining whether a juror can serve fairly and impartially in a given case by asking the juror various questions. Oh, it's French. Terms are Latin. To seek the truth is what it said. That is what's going on in the Karen Reed case right now. Judy, do you know, are they done? Did they pick all? Wait, how many does she want? Did she still want like 19? Or is it 16? What was the last thing you sent me? $15 is what you sent me yesterday. Why is Recovery Addict just now going live? Oh, no. It says 1:24 p.m. Why am I just now getting a notification? Weird. He was live when, I don't know. He was live when I left. Because I left to come over here. Oh, well, you could have asked. I don't know everything, but I know some stuff. And what I don't know, I asked Alita. Although half the time, Alita doesn't know how to dumb it down enough for me. She tries, bless her heart, but half the time I go away more confused than I was when I asked her. And most of her videos now are about Blake Lively, but she did one the other day I wanted to watch. I can't remember now what it was about. Let me see if I can look it up without crashing StreamYard. And voir dire is weird because some places, I don't know, some voir on what kind of court it is. I've heard some people say it depends on the state. I've heard other people say it just depends on the person saying it. So I don't know what the difference is between voir dire or voir dire. I say voir dire. I don't know. No, it's not even going to bring it up. I don't know why StreamYard takes up so much bandwidth. It's crazy. Do it on my iPad. Oh, she's got one on Gene Hackman. Oh, it was the Casey Anthony one. But she's got one about Aaron Goodman, about his wife putting the hit on him too. Cool. So she's got several out now I want to watch. Awesome. I don't give a flying flip about Blake Lively. At all. I just think she's another entitled rich person that's complaining that she's been slighted when she really hasn't. And I have no use for people like that. I'm trying to ruin somebody else's life because you didn't get your way. She's another Amber Heard as far as I'm concerned. I know it's not the same circumstances, but still. Not that y'all asked, but is tomorrow Good Friday? Is that a holiday for the courts? It should be. I think it should be anyway. Why is there no court on Monday? Oh, Peter's live today is about Lori Daybell, that witness telling her to get over herself. I think I'm going to watch his recaps of Lori Daybell. He does good recaps. He picks out the important stuff. Maybe not the important stuff, the spicy stuff. Aw, thank you, Carla. I mean, if you'd rather watch with the other person, I mean, with more experience and more knowledge, I don't mind. I'm just having fun. This, like I said earlier, this is just like a watch party with my closest friends. I'm just like Joe Schmo with a computer. That's all I am. Oh, these are just her holidays? Jeez. It's Easter weekend, right? Is it Easter? Oh, no. Next weekend's Easter. Next weekend is Easter. Next weekend is Easter. I'm getting an injection in my back. Well, it's not in my back, really. It's in my butt. My butt muscle. And it's because of the fibromyalgia, because the big muscle tightens up and squeezes that nerve. And it's at 8 a.m. So we're going to have to start late that day. And on the 14th, I have a sleep study that night at 8. I have to be there at 8 and it'll be done at 6. And I'm 45 minutes away. And court starts at 9. So I should be back in time. So we just won't do Phil Spector on the 15th. I'll just come home and hit the computer and we'll just start with Karen Reed. Same thing on the 16th. We won't be able to do Phil Spector. So on Monday, the 14th, we'll just go long with Phil Spector to make up for the 15th and 16th that we're going to miss. There, that solves my problem of what we're going to do on Monday. Because I was like, what are we going to do on Monday? Because this is going to be over. And like I said earlier, I don't know how to do jury watch. The last 2 trials, I think, that we've gotten super quick verdicts on, I have said, okay, I'll let you guys know when we have a verdict. And then I've walked away from the computer. I left the computer on and I walked away and I started doing other things. And then I had to run back over here and get everything set up really quick because the verdict came back in so quickly. In fact, I still don't think I put up a thumbnail for the rose petal, whatever that one was called. And Ashley Benefield, I don't know if I put up a thumbnail for that one either. That one came back at like midnight. I think I was in my pajamas when I did that one. Because I got a text. We have a verdict. I was like, what? It's midnight. Are you kidding me? And I just don't know. Oh, don't say it like that. I have such mixed emotions about this case, y'all. I don't even know. I still don't know. I would have to be I mean, the other cases I've covered, I have a definite opinion about. Even cases that throughout the evidence I've said, I don't know, this is a weird one, whatever. By the time we get to the end, I have an opinion. Like, I have an idea. This one, if I was on this jury, I would have to like talk to the other jurors, look at all the evidence. I honestly don't know. I feel like she did it, but I don't feel like they have proven that she set this fire. And even in her closing, she's like, maybe she was gonna tip over a candle. Maybe she was gonna do this. Maybe she was gonna do that. It's like, that's reasonable doubt right there. And then the people in RA's chat was like, no way he set himself on fire. Well, duh. People that start fires and burn themselves don't mean to burn themselves. A lot of people will burn themselves when they start fires. Like pyromaniacs that start fires burn themselves all the time. It comes with the thing, you know, it's part of the deal. If you're going to start a fire, you could get burned. Not that I've seen or heard. But when I Google, is Todd Mullins getting a new trial? All I get is all these articles about the post-conviction hearing. Let me see. How else can I word it? Did the judge and the Todd Mullins case decide on the new trial. Oh, it's Mullis, not Mullins. Whatever. Oh, I know why I was thinking Mullins. It's because the judge that got shot. Well, this says. Oh, that's his appeal. That's not the same thing. How do you spell this man's last name? I don't see anything. It's all like from a month ago. Oh, wait a minute. Nope. That's 2 years ago, April 18th. There's a Facebook group called. Wait, where'd it go? There's a freetoddmullis.com. And there's a Facebook group called Justice for Todd Mullis. Nope, no decision yet. Nope. Oh, bye, Carla. Okay, Judy, do I need to press play again? Oh, crap, I do.
The one thing
Shoot!
Judge Brickley will tell
How do I keep doing that? Dang it.
you, this is the only time, excuse me, that I get to speak to you. I want to thank you on behalf of Linda Stermer and our team for the attention you paid throughout this case. Everybody took notes and asked question after question after question. So I know you're paying attention, so thank you. I want to tell you a little bit about your job. When you go back to the jury room, you actually have 3 jobs back there. One, obviously, is to decide the facts of the case and how they apply to the law. The second job you have is to make sure that everybody on this jury follows the law. And when I say follow the law, when you were sworn in and we selected the jury, a lot of questions about the presumption of innocence, the burden of proof. As Linda Stermer sits here today, she is innocent. As Linda Stermer, when you go back into the room, when you walk through those doors, she is innocent. That is a solemn oath you took to hold that throughout this case. The third job you have, when you go back there, is to explain your position to the 11 other people on the jury, how you saw the evidence, what you thought about, how you considered it, and to also listen to them fairly and make sure that everybody gets their word. When you follow the law, what I'm saying is you have a right as a juror to make sure that when you go home after this case, everybody followed the law. Nobody bullied anybody else into trying to cave their opinion without following the law about presumption of innocence and the high burden of proof beyond a reasonable doubt. You heard Ms. Zuderveen speak for an hour and a half, and I timed it. She spent 5 minutes on the fire and the cause of the fire. So let me tell you what this case is not about. This case is not about a van impact. You heard Dr. Markey on a witness stand. Dr. Markey and Ms. Zuderveen said what she thought Dr. Markey told you. The one thing that Judge Brickley will tell you is what we say here is not evidence. What you heard from the witness stand, that's evidence. That's what you consider. And I'm sure Ms. Zuderveen didn't intend to misrepresent anything. But she didn't have a transcript of his testimony like I do, like we purchased. So I want to tell you what Dr. Markey said in terms of the cause of death. On page 19, Dr. Markey said to a question, my question. Well, let me just kind of summarize and make sure we're clear before I leave you. The van impact had no connection with the death. The death was caused by thermal burn injuries. Fair? Said, yes, I believe his death was caused by the thermal injury. Dr. Markey's opinion is the official medical opinion in this case. It's undisputed. And the government, the state, with all its resources, couldn't find another doctor in the state or in the country to say that the van impact had anything to do with Todd Stermer's death. It was solely caused by the fire. And Linda Stermer has not been charged in this case with anything having to do with a vehicle impact to Todd Stermer, not even a misdemeanor. So what does that tell us? One, the van didn't cause the death, and the van certainly didn't start the fire. Why did they spend so much time on the van? Well, I'll tell you. Because they wanted to distract you from the fact that they have no evidence of how the fire started. This case, ladies and gentlemen, the charges are first-degree premeditated. Stermer intended to kill her husband, thought about it for some time, and then carried it out. But the carried it out part is she's charged with felony murder. The felony is arson. So if there's no arson, there is no crime. If there is no crime, there is no premeditation. And so when you consider what you need to do is look at two things. Was the fire intentionally set? And if it was, did Linda Stermer set the fire? Those are the simple issues in this case. The burden of proof for the state is extremely high. Let's talk about that. Burden of proof is beyond a reasonable doubt. Reasonable doubt, ladies and gentlemen, simple terms, is doubt based on reason and common sense. If you have any doubt, as you look at all the evidence today that I'm going to show you and summarize the evidence, if you have any doubt that doesn't require you to abandon reason, then that's reasonable doubt. And what is a doubt? Well, remember I explained it with Mr. Leroy, to lack confidence in, to not trust. That's doubt. In a criminal case, the burden of proof beyond reasonable doubt, in this case, burden, freedom, our founding fathers made sure that they couldn't just say, we don't like you, we think you're guilty, we're going to put you in prison.
Anything but a purple screen.
More likely than not,
Stop.
is it probable? Somebody says, I'm pretty sure, I think she probably did it. Not good enough. So these are the burden, the things you need to consider. Very probable. I think almost for sure she did it. Not good enough. And here's the other thing. In a civil case, the highest burden we have in a civil case is called clear and convincing evidence. That's not good enough. What does that mean? So when you go and address each other in the jury room, clear and convincing evidence under law is to be clear and convincing. The evidence must be strong enough to cause you to have a clear and firm belief that the proposition is true. not good enough. Somebody tells you in the jury room, she set the fire intentionally, not good enough. If you have any doubt as you look at the evidence that is supported by reason and common sense, no matter how small, that's reasonable doubt. And the jury is to return a not guilty verdict unless the government, unless the state meets that high burden, exceeds beyond a reasonable doubt. Your job as you go in there, unless they do that, is to return a not guilty verdict. The other presumption is a presumption of innocence. Morano will review the law, and the law says this. We start out with the presumption that where there's a fire, the law assumes that it had a natural or accidental cause. The prosecutor must overcome this assumption and prove beyond a reasonable doubt that the fire was intentionally set. You start with the presumption that's an accident. So that's the lens you need to look at as you go through this case. You know, before we started, we got one of the jurors asked, why would this case take 3 weeks? Should it maybe take 2 weeks? Because after all, it is only an arson case. Todd Stermer died of a fire. So you just have to decide whether the fire was intentional. And if it was, 2 issues. Did Linda Stermer intentionally set the fire? Instead, what you heard, and I counted the witnesses, 20 witnesses over 1 week to talk about the van, to talk about infidelity, to talk about other issues. And why? Because the state wanted to distract you and distract you from your job, which is simply to decide, was this an intentionally set fire? And it's interesting. In opening statement, and I had that, everybody took good notes, I'm sure, so you'll be able to go back to opening statement. The prosecutor never said what caused the fire. And here, after 3 weeks, Ms. Zuderveen spoke for an hour and a half and spoke for 5 minutes on the fire. And the best she could do is say that Scott Leroy said the fire was consistent with being intentional. You don't get a conviction based on it would be consistent with being intentional. Experts, as we'll talk speculative opinions that Mr. Leroy had and possibilities. You heard from every legitimate expert in this case, starting with the MSP chemist, Troy Ernst. We don't engage in speculation. Speculation masqueraded as an expert opinion is misleading. So that's why we don't do that. Your decision must be based on the evidence that is clear, credible, and compelling factual evidence, not speculation and guesswork. So when you deliberate, you start with the assumption and the question, assuming Linda Stermer did not set this fire, did the prosecution meet its burden of proof beyond a reasonable doubt for every fact it needs to prove to meet those elements, those boxes that she talked about? And if they can't rule out reasonable doubt, if they can't rule out alternate causes, if they can't rule out alternate theories, if you can't rule it out, that's reasonable. And we'll talk about that as we go through this. You're being selected, and you'll remember this. Ms. Zuderveen, when she was asking you questions, asked you this. It might take, to present all the evidence, we might be here for 2 months. So will you give us a pass? Will you not hold it against us if we don't give you all the evidence? You're darn right you have to hold it against them. They have the burden of proof of bringing all the evidence they have to establish guilt beyond a reasonable doubt. They don't get a pass, and you can't give them a pass because they didn't bring you evidence. We'll talk specifically, but I do remember one thing I wanted to bring to mind. There was that video, remember Deputy Gruss did the in-car video, and it showed 10 pictures over 9 seconds. One of the critical issues in this case, as you remember, is how fast was the fire, the speed of the fire, the direction of the fire. 10 stills over 9 seconds. I asked Deputy Gross, what happened to your video? I don't know. Don't you think it might be better, since we're talking about speed of fire and direction, if we had the video? Would that help? Yeah, that would help. But they didn't have it. So they can't help you with a critical decision in terms of the speed and propagation of the fire. So when you think about evidence that they say they don't want to show, that they don't have to show, can you give us a pass? Don't hold it against us. You hold it against them. So why is Linda here? Why is Linda Stermer, that for 18 years sitting in the defense seat? Well, how about there was a house fire, and as soon as the police got there was a man who died, and then there was blood on a bumper. So they rushed to judgment and automatically assumed someone's dead, someone's alive, blood on the bumper has to be a crime. And you remember Sergeant Leroy, when he arrived on the scene, spent a lot of time telling you about the pictures he took about the bumper, because he suspected it was a crime. He took more pictures that night of the vehicle than he took of the house. He is the state's origin and cause expert. This became a rush to judgment with no evidence. In fact, what it really was, as you will see, this was a prosecution looking. No, they wanted to show you the why. But they spent the whole case and the whole afternoon talking about motive, because they wanted to show you the why so you wouldn't focus on how about the where, how about the area of origin, and more importantly, how about the how. You go through your notes and I'll summarize it. You will not find anything where he said he could identify the cause of the fire, how the fire started. And if you can't identify the how and even the where, then you certainly can't identify the who. This was a prosecution looking for a crime working backwards. And all because they found blood on the bumper. Within a couple hours, had a target on her back, husband, and they make her take her clothes off.
Same yard.
But one thing, as you look and listen to Ms. Zurveen, one of the things that she was talking about.
It's a good closing. It's a very good closing.
Motive was the idea of they were in debt and she had a financial motive and she wanted to get money money so they could clear the debts and whatever. For 2 days after his investigation, he's a 30-year lawyer doing nothing but exams under oath, trying to detect fraud. What did he say? And your notes will say this: there was no financial motive. I looked. There was no financial motive, no romantic motive. So when we said here, it's all credibility. We lawyers, we hope we have credibility. We hope what I tell you is backed up by your notes and the evidence. But what Ms. Zuderveen told you about a financial motive was completely opposite from what the witness said. It certainly wasn't about romance and sex. Now let's talk a little bit about what Sergeant Leroy did, because we're going to talk about, remember we talked about the scientific method, you probably did too.
It was a good closing.
I used to be an engineer, and sometimes it makes my eyes glass. You have to collect the data. Most important step. This is always for these fire guys, figure out the ordinate cause. All the available data that you can that might be relevant to the task. Even Sergeant Leroy said that. All the available data, remember? Witness statements, building records, we'll talk about those. Physical inspection, excavation. Collecting data includes excavation of the property. That's where the gold is. That's where the evidence is. That's where you find the burn patterns and the objects that show you where the fire started and what could have caused Leroy under oath. And he admitted this. Remember this? If you don't collect the data, you can't analyze it. You have nothing to analyze, which means that, and you can't select a final hypothesis if you don't do every methodology. And if you have an unreliable methodology, what does he tell you? You have an unreliable opinion. It can't be relied upon. It can't be trusted. The very definition of doubt. Garbage in equals garbage out. So we're going to talk about all the various things he did and whether it complied with scientific method like he said he did. Book, which every single fire investigator trains to, tests to, and teaches to. NFPA 921. There were some questions about, this is 2024 version. It's been going on every 3 years since 1990. Scientific method. 2024 version is what is in effect, what you have to comply with. And you might say, well, why are you holding the guy to 2024 when it happened in 20?
StreamYard, what in the fudge are you doing? You're driving me crazy. Knock it off.
Your opinion based on new developments. And in this case, Follow the steps. That's fundamental, was fundamental in 2000. Been fundamental for decades before that, the scientific method. So let's look at what Sergeant, and then under oath, he told you, he went through the man who you heard from yesterday, an area 20 feet by 20 feet by 2 feet, 800 cubic feet of debris. And what does that debris look like?
At least she cheered me up. And I'm just kidding. Please keep texting me.
Oh. Roy's area of origin look like? Right here, that's the first floor fireplace that we've been talking about. Here is a chimney chase that we
of this woman. It's almost over, StreamYard. You can stick it out for another couple hours. It's almost over.
But here is the 2 feet of debris in this 20 by 20 living room. That example. And what was his testimony under oath to you? Greg Storms and I cleared the entire living room and deposited it outside. And he said, my pile was 4 feet by 8 feet by 7 feet. That's nowhere near an 20 by 20 by 2 cubic feet. That's about 28% of it. I had a calculator. And what did it look like when the next person came? The next person who came was Mr. McHugh. You remember that? And he took a picture.
It'll be tomorrow. I don't think they'll
On the
even
back, he was there on the 10th. And he testified, I think it was yesterday, maybe the day before. In all. And then Jinsky came a couple days later on the 11th. And his picture is better. But I ask you, where is this 4 foot by 8 foot by 7 foot high pile that Mr. Leroy said he actually almost said, I don't know, maybe. Here's the thing. Remember Mr. Shinsky? He said, I had to come back on the 15th with an excavator because it was too dangerous. So if it's too dangerous for a veteran like Mr. Shinsky, who, by the way, trained Mr. Leroy, then you know Mr. Leroy wasn't doing any excavation of the whole living room floor, and there was no clear 20 foot by 20 foot area. Shinsky's picture, after they came back with an excavator, you remember, and there's the living room goes out to what would have been the bay windows. Look at all that rubble, look at all that debris. I could basically, and by the way, he did the excavation. How do I know what he exactly said? Because I have his transcript and we have his words. And his words were, in reference to the structural damage, you would then have to contract with someone. You did the excavation yourself? Yes. Physically, hand by hand? Physically, hand by hand, and hired an excavator so we could remove the areas of the house that were hanging over the berms out.
Streaming. Stop.
And then this half truth, sometimes you just got to keep asking questions. And then you get to the truth. And then he says, I didn't take his testimony, Mr. Shinsky's. And what was his excuse? It was a long day. I was tired and I forgot. You remember I asked him, would you take that answer from somebody you're training? What was his answer? Yes. Well, it depends on the fire. This is a death case. It doesn't get more serious. Like Mr. Stormzan said, you have to bring your A game. Leroy, I can say it in lawyer terms, his story was demonstrably false. But if we want to just be real, he lied to you. And if he lied to you, you can't trust his opinions, because if you can't trust the messenger, you can't trust the message. So when you go back and you analyze Mr. Leroy's work in this case, think about that. He lied about the very thing he needed to do, step one, collecting the data, so he could get to the conclusions, so he could develop the hypotheses, so he could try to figure out what went wrong and caused this fire. And you know what he said about that? He said, I didn't take any evidence because it had no evidentiary value. You see, there's that half-truth again that Ms. Zuderman has been talking about. You're right, you didn't take any evidence because you didn't look to find any evidence. When you analyze what he's doing, look at it in terms of his credibility and the high burden of proof. If you have any reasonable doubt about any of his opinions, especially when he lied to you, that's all you need. And when you have one reasonable doubt, ladies and gentlemen, about any issue, your job is done. Your job is done. Once you find one reasonable doubt.
There's only two questions, really. You're going to hear, and I'll tell you about the verdict form and first degree felony murder, first degree murder, second degree murder. It's all about, did she set a fire and was it intentional? That's it. And you remember, well, we'll talk about it in a little bit, but as I said, one of the jurors was talking, we were talking about half-truths. When my kids, I think they're lying to me, I just keep pressing, and then I get the answer.
Oh Lord, this man has
We kept
kids.
pressing, Leroy, and then we got
Poor
the
kids.
answer. So I want to look at these experts in this case because this is very important. 50-year veteran, got born and raised in Detroit, cut his teeth in Detroit, literally the murder arson capital of the world back then. He has trained people, taught people, tested, been on committees. And what did he tell you? He spent 2,000 hours in this case, 2,000, over about 10 years. And when I asked him, how much you charge? Like $250 an hour? And then Mr. Blair came up, he couldn't wait to do the math. And they said, I'm not charging anything in this case. I think there was a question. You're not charging anything. This is America after all. You must family with Linda Stermer. In this case, he knows every piece of the evidence. He knows everything that Leroy did and Shinsky did. Leroy spent less than 6 hours on the scene and developed his report. You know, he spent more time testifying, defending his opinions than he spent on the scene getting his opinions. And when you think about this, these are real questions that need to be asked when you go back to the jury, these kind of devil's advocate, cynical questions. Mr. Shinsky is a veteran, way more experienced than Mr. Leroy, taught Mr. Leroy. Mr. Shinsky was actually at the house, as you saw, same time Leroy was, same week, did the excavation, did an investigation. Why didn't they hire him? Why didn't they hire Mr. Shinsky to come in and tell us how good Leroy's opinion was and his methods? Maybe because Shinsky said, I did the excavation, and he would have known that Leroy lied. And the other thing is, Mr. Shinsky was asked to read. They hired him and asked him his opinions. Maybe because he disagreed with Mr. Leroy. And if you think there's any chance that's supported by reason and common sense that Shinsky disagreed with Leroy, that's an intentional fire, and maybe he did determine based on all the damage that it's undetermined, like Mr. Trinkle. That's why they didn't retain him. That's why they didn't hire the second most experienced guy who you saw in this case. And you know what? Greg Stormzan was with him. You remember he was his partner on that excavation. Stormzan said, well, you got to document so people can understand what you did. And it'd be the guy who was supposed to, I was just assisting because it's not my jurisdiction. He's the one who's supposed to take photographs. He's the one who's supposed to report. He didn't. You can't just omit this stuff. And when you think about this poor excuse of I was tired and I forgot, did you forget to write a report? Would you forget you were tired when you were writing a report and left out the excavation? Or maybe you didn't do it. Maybe you didn't do what you said you did under oath. Anything that's supported by reason and common sense, no matter how small, that's reasonable doubt. And when you get one reasonable doubt, you're done. Not guilty. By the way, Mr. Leroy really kind of has an inherent conflict of interest, and nobody's defending him. Like I said, he spent more time in the last 18 years defending what he didn't do than he spent getting the evidence. Follow the science, ladies and gentlemen. When you look at what was done here by Leroy, follow the science, what he collected, what he analyzed in 2007, and not what they're trying to suggest. Well, so-and-so backs you up on this in 2024. That's not when he did the investigation and the lack of excavation. 2007 is when you hold him to the evidence that he collected and his analysis. Follow the science, follow the objective evidence. We brought you objective evidence. And by the way, defendant has no burden of proof. We don't have to show you anything. We didn't even have to call a witness, but we did. Called Mr. Trenkle. We called Dr. Z, who said this is a 5 mile an hour impact. We'll talk about that as it gets to whether Linda Stermer intended to do anything. But let's talk about the reasonable doubt in this case. His conclusions. And so I didn't want to write it on the board. My handwriting kind of sucks. Here, Leroy's opinion of not reliable. Garbage in equals garbage out. And there was a whole lot of garbage in what he didn't do. You can't trust his opinions because you can't trust his methods because he didn't do it. He didn't comply with 921. He didn't comply with the scientific method. Did Leroy rule out an alternate area of origin? You remember, Mr. Leroy agreed with me, his living room here is about the size of this courtroom, all the way to the bench. Sometimes, as you saw NFPA 921, it says, sometimes the damage illusions. You heard Mr. Trenkle. Ideally, you're trying to get to a point of origin. It was the back of the toaster. It was the electrical outlet. The bigger you get, the worse your reliability of your opinions are going to be because they're just too much. Think about this. I stood here. Could the fire started here? Don't know. Could the fire started there? Don't know. Could the fire started there? Don't know. He can't tell you the where. If he can't tell you the where, you can forget about it. Because remember what NFPA 921 says? If you're not in the right area of origin, you can't find the cause. Because the cause is going to be in the area of origin. But if you don't look, and if you don't excavate, you will never find it. So then we talked about alternate areas of origin. And remember that chimney. And Mr. Trenkle said, witnesses yesterday about, first of all, how everybody talked. This house was unfinished. Whole living room. You didn't hear them bring anybody to say it wasn't. They could have asked the two boys. They had them up there today. What about the chimney? They didn't ask that question. There's a reason they didn't ask that question. They didn't want to hear it out of their own witness's mouth. Could the chimney chase reasonably be a possible area of origin? Well, Mr. Trenkle told you it's consistent with the witness reports of a fire from the back rear of the place, flames shooting out of the roof, chimney chase. That chimney chase is 2+ stories high. And if you have a problem in the chimney from the flue, which you saw the rubble, he didn't even analyze, then you can have rubble pouring down. And by the laws of physics, things don't drop straight down. They go in arcs. They go out and down in an arc. And when you have a wall collapsing, that would be consistent with getting Todd in the living room. That would be consistent with his burns on his hands. And that would be consistent with a pretty sudden fire and him screaming. So we don't have to prove that it's the chimney chase. We're not here to prove that the chimney chase is where the fire started. He can't rule out the chimney chase could logically possibly be the area of origin because he didn't do the work. And if you can't rule it out, that's reasonable doubt. Let's look at the next one. Gasoline was on sweatpants, not related to the fire. Can he rule out that maybe the gasoline he found on the sweatpants had nothing to do with this fire? Well, you remember his testimony? At least he was candid with me because I had his old testimony from 4 years ago. He has no opinion on whether the gas on the sweatpants had anything to do with this fire. He said, I don't know how it got there. I don't know where Todd was when it got there. I don't know when it got there. I don't know when the last time the pants were washed. I don't know any of it. So finally he was candid enough, because I had him trapped, to say, I don't know. I have no opinion. Well, that's the whole linchpin of his whole gasoline in the house, because he admitted there's no gasoline in the living room. None was found. None. If he can't rule out that the gasoline has nothing to do with this fire, then you have to return a not guilty verdict, because that is reasonable doubt. That's the whole basis of his opinion. I'm sure you folks have notes on that. Now, this is important. The other thing that can cause reasonable doubt is, do you remember when I was asking about his opinion, he relied on Linda Stermer. Was upstairs, she's downstairs, about all the inconsistent stories. What you've heard from every single witness who talked to Linda Stermer is that she was downstairs and Todd was upstairs when she heard this horrible scream and he was on fire. And she ran upstairs, and then her world turned upside down. So, my easel finally. Todd was upstairs. Linda forgive me, that's how my mom used to draw her when I was a kid, was downstairs. She was downstairs and had to run upstairs. Even Sergeant Leroy agrees with the obvious. You can't be two places at the same time. That means when he caught on fire, she wasn't there. She wasn't with him. And the oh, wait. When Mr. Blair apparently realized this is checkmate on reasonable doubt and where the fire started and caused the fire, he started asking, well, isn't it possible that maybe she could have poured gasoline on him and ran down the stairs and there was all these fumes and getting gas on her after doing 0.5, not a drop, not a speck on that high-tech machine? No, there's no such thing as possibility. You heard every legitimate expert say, we don't guess, because guesswork masquerading as expert opinion testimony is junk science, and it's frankly unethical. We don't do that. So this idea of they'd like to show possibilities, you don't deal in possibilities. You are the judges of the evidence, but the evidence from their expert, I'm not an expert at fire science. You're not presumably an expert at fire science. You have to rely on the evidence that you heard from the witness chair. And the evidence from Leroy and Mr. Trinkle was she was downstairs, he was upstairs. She wasn't with him. If there's any reasonable doubt that she had nothing to do with the fire, not guilty is your job.
Chris was done with her, right? Didn't he say they broke up?
No evidence of an ignition source. Let's talk about that for a little bit. Because you don't collect any evidence, he couldn't find any evidence of an ignition source. You remember we talked about MPA 91 and factors. Causal factors, if you'll recall, you look at your notes, are you have to have an ignition source and you have to have a first fuel. Ignition source, what's the thing that made something catch fire? If you're at first fuel, what's the first thing that caught fire? And most importantly, how did 1 and 2 come together? He didn't have any evidence of an ignition source, so he supplied one and said it's an open flame. Could be from the fireplace, could be from candles, don't know. Well, he didn't rule those out either. And then he said gasoline, but see, this is circular because he said gasoline on the sweatpants, which he's admitted he didn't know how long it had been there, means there's gasoline in the house.
Working on
He
the
didn't have a
tractor or
first fuel.
something.
And he certainly couldn't put 1 and 2 together to tell anybody what caused the fire. How did the first fuel, even if it was open flame, 2, gasoline, how did it come together? What's the first thing that happened? Doesn't know. What's the second thing? Because you have to, as an expert, you have to do this. You have to say, this is the first thing that caught fire. And based on our training and experience, we know the fire propagated this way. This caught fire, then it caught that fire, and it caught that fire, and it caught that fire. You tell how the fire started and how the fire progressed. He couldn't do that because he didn't do step 1 of the scientific method. He didn't collect the data. Garbage in equals garbage out. And when there's garbage for the out because of garbage from the in, that's reasonable doubt. Doubt calls into question the confidence in his opinion based on reason and common sense. Reason and common sense tells us you can't be where the fire started if you're downstairs.
There you go, just because there's another one.
He couldn't give us the how. Frankly, he couldn't even give us the where because he doesn't know within this huge area of origin where the fire started. Number 9. Since he couldn't tell us the cause, he certainly can't tell us the classification. Accidental fires, natural fires, lightning strikes, undetermined, and incendiary. Incendiary is the only classification that supports a crime. And if you don't have a cause, you can't have a classification. If you don't have a cause, the only intellectually honest thing you can do with integrity and honesty is say it's undetermined. And there's no shame in that. Because sometimes fires are just too total. The damage is just too much. Did he rule out an electrical or mechanical cause of the fire? Well, he's admitted he's not an electrical expert, and he's admitted under oath that he didn't collect anything. So how could he rule something out that he didn't collect?
Oh,
And
you're
what did he do?
keeping track.
He explains that, well, electric
not.
fires and walls, they start small and slow, and so this is why this whole able-bodied thing comes into play. And an able-bodied person, if it was electrical, could figure that out and escape. Electrical fires in the walls can explode all the time. Happens all the time. Did he exclude and rule out a mechanical cause? The flue. You saw all that damage to all the flue pipes. That's why we bring in people and they look at it and they try to see what could have been a failure of the flue. And that's how things started in a chimney chase. He's not an expert. He said that. He didn't collect the data. You saw how Shinsky laid out the stuff like you're supposed to do. What did Leroy do when he was tired and it was a long day? He threw the stuff in a pile in the back of the house. And forget about 123. Nope, 30. We'll get it. You remember Shinsky's photo. He just piled it. There's no analysis. There's no thorough investigation. There's no thorough, rigorous testing, which is what NFPA and a scientific method say you have to do. He just threw it out so he could go home because he was tired. And remember, I asked, why didn't you just come back the next day? Didn't have an answer for that. Wouldn't you have told your young associate? Nothing wrong with going back. Why didn't you go back? And why didn't you write a report? And why didn't you do what you were required to do in this death case? Then he didn't rule out contamination of the sweatpants. Remember, he found 3 hours later Todd Stermer, and he smelled gasoline. We'll talk about that in just a second. He smelled fuel. I shouldn't say gasoline, because he said, at least he was honest. Fuel is fuel when you're smelling it. I don't have a super nose. So he smelled fuel, and that's why he took the sweatpants. But remember, he's there 3 hours later, and this is the final point of rest for Todd Stermer after he's been taken in this boat to here. So if you find in here, you have to analyze, could there have been a transfer to the boat? Or you remember, Matheny put clothes on him, a bunch of clothes, and they found that here, right? Could there have been a contamination from there? It's not whether there was, it's whether he can rule out the logical possibility that there was. And how do you do that? You use the scientific method like all scientists do, like all professionals do, and you collect data, starting with the boat, working backwards. I asked him, did you use a rag, anything? No. Did you talk to anybody? No. Talk to the family? No. I don't even think he knew the boat involved. So he couldn't collect the data, so he couldn't do the rest of the steps, so he couldn't comply with the scientific method, which means that his methodology is garbage, so any opinion that says that didn't matter, that's garbage too. If he didn't rule it out, that's reasonable doubt. These are 11 different things that I've come to. When you go back, you were taking a lot of notes. Did he consider that? But you don't take possibilities. Pros don't take possibilities. So when there's Zuderveen, like Mr. Blair says, was it possible that this happened? That's not evidence. That's speculation. That's guesswork. Experts don't do that, and you can't accept that as valid evidence. Not only was there Mr. Leroy's shortcomings, but you remember a lot of the police witnesses who testified. Oh, let me segue here. Let me just back up just a little bit. Do you remember all of a sudden, remember this fire chief who had been retired for a lot of years, and he was comes in and he said, I've done, hundreds of fires. And all of a sudden he remembers, yeah, I'm writing a report 18 years ago. He's never said that ever in any document. But he admitted, I met with the prosecutor and we talked about what my testimony was going to be. So it's kind of weird that all of a sudden people 18 years later are saying things that they never said and never wrote. So when you consider credibility and the credibility of the witnesses as you're analyzing whether there's reasonable doubt, think about that. Every law enforcement person who came in and said that they smelled fuel at the scene on never said it before and met with the prosecutor to prepare. One more thing I did forget. There was talk about the construction of the house. And this is real important because as you're analyzing, how could the fire have started? Could it have been an accident? Remember Brad Stermer, the older brother? He said, I was in college, and remember we had that yellow house that was my dad's, and Todd was the main guy working on it. And he said, I'm a handyman, and I'm good at it too. But we didn't have any money. I think the phrase was, we were scraping nickels together to get it fixed. And he admitted, we didn't use the best equipment, the best components as we were doing the house. And 5 months after they finished, with Todd at the helm, being unlicensed, that place burned. And he said that was an accidental fire. Well, that can happen when you don't have licensed contractors. And good as you may be as an amateur, you're not a licensed electrician, you're not a licensed mechanical person, HVAC, nothing. That can happen. And you can't rule out that happened in this case. And no, we know why. Because it took, what, 6 years for this house to be built? You're scraping nickels if it takes 6 years to build a house. You're doing what you can when you can afford it. You heard, and maybe it's because of the horses, but you heard they were having money troubles. That's why they didn't build it. That's why they were scraping nickels. And he was at the helm. And you heard, not only did you hear from all the people who've been in the house about all the exposed wood, which is why it would have gone up so fast because it was a tinderbox. Then you heard the last witness we had, Rich McGrew, who said, if you don't get a final electrical, a final mechanical, and we don't certify it as good for final occupancy, it is a unsafe house. Why unsafe? Because you can have fires. So you're not here to supply evidence. You're here to address the evidence that was given to you. And in that sense, you can't rule out that because of poor construction, this could have been an accidental fire. And the fact is, because it's a tinderbox, that also explains the speed of the fire. But at least Leroy was candid enough when I questioned him and caught him in some demonstrable untruths that he said, yeah, I didn't know how the house was built. I didn't know that it had OSB flooring. I didn't know that there was no final certificate. I didn't know that it didn't have final inspections. That's all data that you can collect that's available. You know who collected it? Len McHugh, the property adjuster, who, by the way, Linda Stermer asked him, why are you here? Because we don't have insurance. We'll get to that in a second. But he's the one who collected the available data, he said, from the building department, which is what Leroy could have done, but chose not to. Garbage in equals garbage out, makes it unreliable. It can't be trusted. And if it can't be trusted, that's reasonable doubt. Now, let's talk about the police work in this case, in this rush to judgment, where they first, I will say, they got misled by Leroy, who called it an incendiary fire.
Common
So in their
sense.
terms,
How
in
many
the police
times he
terms,
said common
that's an
sense?
arson. And we have a guy who's dead and we have blood on the bumper. Now, their rush to judgment resulted in all kinds of sloppy work. First of all, this missing video that we're talking about, which would have helped anybody, including a defendant who's under arrest, determine how the fires was spreading, that's gone. You heard Cynthia DeLoach, the gas station attendant. I asked Maciaski, you got the cash register tape and the video from the place in February of 2007, a few weeks after. It's stuck in your drawer for 2.5 years. And is that proper protocol for property preservation? I'm not sure what the protocol was back then. You're a veteran cop. Your command staff. You don't know this? Or is this just another half-truth? Mislabeled evidence. Remember that coat that was in the silver can that turned out to be Mike Matheny's coat, that red checkered one? That was labeled Todd Stermer, which helped Leroy determine, well, everything that's tested positive for gasoline is Todd Stermer's. Therefore, couldn't be any contamination. He didn't realize until later, oh, that's Matheny's coat. And he didn't rule out the contamination from Matheny's coat or the boat. If we didn't rule that out, that's reasonable doubt. Witnesses weren't interviewed for 2.5 years. Cynthia DeLoach didn't get interviewed until 2.5 years later, June of 2009. And remember the testimony from her? I knew Deputy so-and-so, and he'd come in all the time. Have you talked to the folks? Have you talked to my bosses, whoever's running the investigation? No, nobody's come to talk to me. Remember Maciaski, who said, I got too busy. I forgot. Everybody seems to forget here. He got too busy. He didn't go see her for 2.5 years. When you look at it with a bit of a jaundiced eye, this other detective, if he's going to Cynthia DeLoach, what'd she say, every month, every 2 months or so, have you talked to us? Have you talked to our guy? Have you talked to our guy? You think he's not going back to the department? Why don't you talk to this woman? She's got evidence. He didn't do it. And by that time, she forgets, because you heard her testify. I don't know if Linda Stermer was pouring gas. I didn't know. She should have said, I think she was, but I didn't see a container. Now, think about this, because I want to talk about this red gas can that was found in the front yard. And they're trying to relate it, one to the fire and all the way back to Cynthia DeLoach. This gas can that was found by Leroy, you can see has a broken spout. He didn't know how long it had been there. This gas can that tried to relate to and make this big conspiracy by Linda Stermer, she went and bought gas in the morning and she put gas in the truck. Linda Stermer is all about 5'6". Chevy Blazer, remember the talk was the hatchback. 5'6" woman doing this into a gas can, and you didn't spill a drop of gas. You didn't spill any gas. You didn't get it on your clothes. You didn't get it on your hand. How do you pump 4.5 gallons into a 1 gallon tank? You don't, because there was never any gas being pumped into a gas can. And how do we know that? Because Trevor was honest enough when he testified to say, remember when we went to the mall in the Blazer? I didn't smell any foul smell. You know what gas smells like, right, Trevor? Yeah, I know what it smells like. You didn't smell anything, did you? No. Anybody, including me, when it's time to use a snowblower and I gotta go to the gas station with my gas can, I put it in the truck with the SUV, it smells. And I may not spill a drop. But anybody who spilled gas on clothes or their hands, it reeks for a while. So when you think about credibility and what is trying to be portrayed as this grand scheme, reasonable doubt. Was this even connected? No. The most telling evidence is their expert, Leroy, said, I have no idea. It has anything to do with it. So what you're being told by the prosecutor is some theory based on no evidence, trying to connect dots. But it's a bridge too far, a road too long. You can't connect dots because all you're doing is guessing. And you as a jury have to evaluate the evidence, not the talk of me, not the talk of Ms. Zuderveen. Judge will tell you that. What we say is not evidence. What they said was evidence. Leroy said, no idea. No idea. Now, we have all kinds of reasonable doubt, at least 11 things, just in terms of how the fire started or where the fire started. But now I want to talk about the second part of it, intent. Did Linda Stermer intend to set a fire? Let's look at the objective evidence. Then we're going to talk about all these 5 ways that Ms. Zuderveen said Linda Stermer tried to kill her husband that day. 5 different ways, and we'll analyze that against the objective evidence we have. First, the thought and the theory by the prosecutor is Ms. Stermer struck Todd in the van, therefore she intended to kill him. Well, let's look at that through reason and common sense. And if you lack confidence by using your reason and common sense, that's reasonable doubt. You heard the 911 tape.
My name is Linda Stermer. Linda Stermer? Yeah, oh my God, she I don't know people say, oh my God. She doesn't say no? She doesn't know, but she screams at something to my boyfriend. Okay. Can you see what she's screaming? I know. I don't know. I'm trying to get here. I'm looking here. She has to break it out. Oh my God. Can you tell me something here? Are you able to say what your cell phone and see? Yes. We just want to know if anybody's inside or not. Is there anybody inside? Is there? Oh my God!
That, as you know, was Connie Calhoun, and you saw her stress level, the chaos she was going through. She wasn't in a fire. Her spouse wasn't on fire. Her house wasn't on fire. And you saw how she was. And by the way, every person who testified here from law enforcement or people like Connie Calhoun and Mike Matheny and Dr. Masali all testified she was hysterical. She was beside herself. Now, she would have to be the greatest actress in the history of Hollywood. Meryl Streep would have nothing on her. And by the way, remember the theory that Ms. Zudovine just told you? She was driving down the driveway. She was escaping. Let's look at that. Reason and common sense, and see if we doubt that statement. Who is a mastermind who supposedly got gas in the morning in a gas can to torch a place, scooted the kids out, and then is escaping, as she said, and escaping with no shoes, and escaping with no coat in January, and is escaping with no cell phones in January, and is beside herself hysterical? All it takes is a little bit of doubt based on reason and common sense. And anybody who heard that 911 call cannot come to any conclusion other than she was shocked. You folks, they train so they can have muscle memory when the stuff hits the fan. She's a middle-aged woman who never engaged in any of that. And she acted like it, like she'd lost her mind, because it's fight or flight. And she ran, but she wasn't escaping. She was trying to get help. And it is pretty darn cynical to listen to that 911 call and to say she was trying to escape this mastermind was. Now, there were talk about valuables in the house. One of the things you look at, as any cynical person like Willison would be, is if we're going to torch your house, I want to make sure my pictures of my kids and all my valuable stuff and all my guns and everything else are out of there. Then I'll torch the house. Remember, Trevor's baseball cards that were so valuable to him were found in the basement in the rubble. And you heard from Tina Benny, and she said, my husband and I, we had this handmade little sifter, and we found a wedding ring, Linda's mom's wedding ring, valuables that were in the rubble, by using equipment that Scott Leroy should have been using, that he has, that they use. So this idea of you hide valuables, reason and common sense. And reason and common sense tells you if you have a financial motive, you kind of know you had insurance. Len McHugh said, she asked me, why are you here? We don't have insurance. Our insurance lapsed. This is the financial motive? This is a get rich quick scheme by this mastermind? There's no intent. There's reasonable doubt as to every bit of intent here. Oh, then let's talk about these 5 ways, the 5 best ways to kill your husband in the same day. First, she tried to drug him. then set a fire. Where'd that come from? Kate Fox with a coffee cup, remember? But Kate Fox told us, Linda Stermer said, I put the coffee cup and I didn't drug him because he was already on tranquilizers. Let's look at the objective evidence about that. Dr. Markey told us in no uncertain terms that there are no drugs in the system. And when we talk about who's being square with you and we want to have credibility, Dr. Markey said the remnants, the metabolites of hydrocodone were in the urine. That's not active. There was nothing but caffeine in the bloodstream, the active ingredients. And the metabolites that are in the urine, which last longer, were explained by the medical records that we just admitted today from the C, a narcotic for the ear infection that has hydrocodone. Dr. Markey admitted hydrocodone is consistent with taking this cold medicine that the doctor prescribed. So when we're talking about what the evidence represents, like I said, thank God what we say is not evidence. You can rely on your notes and you can rely on the transcripts. Well, you can't rely on it, I can. And also, Ms. Stermer said that Dr. Markey had no opinion as to whether the skull injuries, the lacerations on the head were related to the van versus something else, which you're suggesting is a frying pan. Dr. Markey said on page 18 in his testimony, those injuries that you saw to Mr. Stermer are consistent with having been run over and striking various undercarriage components, isn't it? Well, the injuries themselves, as I stated before, very well it could be to being struck and overrun and striking things on the undercarriage of the motor vehicle. That's his actual words, not what you heard he said. And you can look at your notes because these are the actual words under oath. And it's consistent with Dr. Zacheski, I just call him Dr. Z, who is a renowned biomechanics injury mechanism expert with decades of experience working with brain injuries, who told you all of the lacerations and these skull fractures. It sounds bad, a skull fracture. A depressed skull fracture has been explained as you take your finger, there's some icing on a cake. It doesn't even hit the bottom of the bone. There's no linear skull fracture. There was no brain injury. As Ms. Zuderveen tried to suggest, Markey said, that's not on the autopsy. These are AIS-2 injuries, Dr. Z said, moderate injuries. Not related, there's no evidence that it was related to a frying pan. So that's the first one, drugs, set them on fire. Number two, crack them with a frying pan, then set them on fire. Except that came from Dardita Gordon, who admitted to so much mental illness and on so many medications normally that she would have been, except she was in jail when she gave that statement. And she said, they don't give me my meds in jail, and I have memory problems. And guess what? She admitted that it was Detective Macioski who suggested, could it have been a frying pan? It was a jailhouse snitch. Yeah, I guess it could have. You look at all of this with a cynical eye, and when you're evaluating the witness's credibility, that's unreliable. That's not consistent with the physical evidence. We don't have to prove anything to you, but we bring you objective evidence, follow the science, follow the objective evidence, and you can't come to any other result other than there's reasonable doubt. And by the way, what devious mastermind who's going to torch the place and kill her husband spends the afternoon packing up Christmas decorations? What, an hour before I'm going to torch my place and kill my husband? None of this makes sense. Starting with all these witnesses who prepped with the prosecutor and all of a sudden change your testimony or hear new testimony. So frying pan is number two. Setting the fire by itself, well, we already talked about that. That's clearly reasonable doubt as to where the fire started, no doubt as to Linda Stermer didn't have anything to do with it. And you didn't hear a single word from Mr. Leroy or the prosecutor that gas on the sweatpants had anything to do with Linda Stermer. Because if they had that opinion, it would have been front and center. It would have been blown up on the wall 10 feet high. No opinion, your notes, you can pull them all. Nobody will find a note that says that. The gas on his pants, which he claims is the whole key to the case, that it had anything to do with Linda Stermer. 4, run him over after you set the fire. Well, you heard testimony from Dr. Z that it's a 5-mile-an-hour impact. And those injuries, you didn't see anything where he was run over by a 4,500-pound vehicle, no broken legs, no broken bones, rib fractures consistent with CPR, no brain injury, no skull injury, no nothing other than icing on the cake and some lacerations consistent with being run over at a low speed, as Dr. Z said, with a high load. High load is just, it's 4,500-pound van. And Dr. Z's testimony is undisputed, because don't you think with the resources that the government has, if they could find anybody, and I mean anybody, to counter Dr. Z or counter Dr. Markey, that they would have? But this is the same group that's letting Leroy defend himself. They won't even hire Shinsky, because Shinsky's not going to go their way. And finally, the 5th way she tried to kill him that day was to suffocate him. So here she is in this panic state of chaos, fight and flight, and out of her mind. And she's yelling, Todd, stay with me. And what did they say? We think she was laying on top of him. She wasn't laying on top of him. She was trying to hold her husband and keep him alive. And if there's any little doubt that you have that's supported by reason and common sense, that doesn't require you to abandon reason, then that's reasonable doubt. And if there's reasonable doubt, you have to vote not guilty. There's no intent here. Clearly reasonable doubt as to the intent and lack thereof. I'm going to talk a little bit about the inconsistencies. And of course, there were a lot. But you know what they were? They were details after she got to the top of the stairs, when her world blew up. While she was downstairs and calm, everything's consistent. I'm in the laundry room, and Todd is upstairs, and that was relied upon by Leroy in terms of finding the area of origin. It corroborated his physical findings. His physical findings corroborated her testimony. Nothing about these witnesses that they're bringing you is being corroborated. We talked about how Mr. Trinkle said how people train so they hope they can combat panic when the adrenaline is high in a stressful situation. And when you're in the jury room, I want you to think of this. A lot of people Monday morning quarterback and go, I wouldn't have done that. I would have jumped on my husband. I would have saved him. While you're having coffee in the jury room or you're watching TV in 2020, I would have done this, I would have done that. You don't know what you would have done. What you would have done and what you could do in the situation are two vastly different things. So when you're thinking about what she was going through, you have to put it through the lens of this high burden, this presumption of innocence, and that none of us know, unless you've been in a fire and running out in your underwear, what people go through. I'll talk a little bit about their witnesses, not much, frankly. Certainly not going to go through every witness of theirs. Let's talk about, we talked about Dardita Gordon. Let's talk about Kathy Ilge, who's the one who said that she talked to me about the coffee cup and the drugs, and that she found jewelry in the van, Linda Stermer's van that she drove, remember, within a week or two of the fire. And in the center console was jewelry, which to a cynic would mean you're kind of squirreling away stuff, the valuables, because you don't want them to burn up in the fire. Well, look at the objective evidence in this case. First of all, you remember Kathy said, within 2 weeks of this, I'm in the van. And in the center console, there's the jewelry. Do you remember the van was confiscated by search warrant that night and examined the next day? The picture of the center of the console of the van, as Maciaski showed, taken on the 8th the next day, there's no jewelry. And Maciaski, who's supposed to put a detailed report together anytime you do a search warrant, it's the property you take and confiscate and take into evidence, never mentioned jewelry because it didn't exist. And here's the kicker. This is a murder investigation. What police department in a murder investigation involving a bloody van is giving the key evidence back to the family in a week? Think about that. When you're back in the jury room and you're thinking about the credibility of these witnesses, no police department. This is a murder investigation, and that is a critical piece of evidence. You don't give it back to the family. Oh, the other funny thing, among many, is that she said, let's strike that. I'm going to go to Kate Fox. But Kathy Ilg can't be believed. Testimony is unreliable. And for them to put somebody who would talk that crazy and that to give testimony that is so demonstrably false by the evidence, you have to wonder as you start to think about these weird things, why are they putting up these witnesses to talk about things that would be impossible, that are demonstrated to be impossible? Maybe because they can't talk about the fire. Maybe they want you to dislike her so much, you ignore that there's no evidence of a fire being caused intentionally. And nobody can prove it. So we want you to dislike her. We don't want you to think highly of her. She had an affair. She said this, she said that. She treated Todd badly. Because we don't want, in 90 minutes, they talked 5 minutes about the fire, why we're here. And then in the 5 minutes, you heard one sentence. Leroy said, it's consistent with an intentional fire. She didn't tell you about the evidence that supported that. She didn't tell you that we don't know how the fire started. We want to give you the why. We want to give you the motive, but we don't want to tell you how because we can't. Let's talk about Kate Fox. Kate Fox came in here dressed really nice and talked about a coffee cup and the drugs. Remember, we talked about Dr. Markey, how he blew that apart. But the other thing that struck me is you were supposedly best friends with Linda Stermer, but because her sons lost their father and she had to take care of them, she had to switch a shift, you felt like she betrayed you? And so maybe you have an axe to grind. And when you look at her credibility, let's measure this against the credible evidence and the objective evidence. Linda Stermer, while she was carrying on this affair, told me to close up her post office box because her husband was going to find out. The federal government allows a stranger to come in and close somebody else's post office box? Really? They want you to believe that? This is who they're putting up as a credible witness to talk about she confessed, she did this. The objective evidence. When you're evaluating credibility, look at what's out there that can't be true. And finally, Trevor Stermer, Trent Stermer, they came on. They both disliked the mom very much. They both only started calling her Linda instead of mom after she got charged in 2009. And they were both living with Grandma Stermer before the trial and after the trial. Just take that in consideration. I tried to be as nice as I could, but I had to point out all the inconsistent statements under oath, and it probably bored you because every 30 seconds I was going, remember, you're under oath, right? And you swore to tell the truth, and you did tell the truth. And eventually, after you ask so many questions, they go, yes, I was telling the truth when I said mom was acting normal that day, which would be consistent with mom's wrapping up the Christmas decorations and putting them away an hour or two before she's going to torch the place. You can't have it both ways. You can't have it both ways. You can't be this diabolical killer, master planner, so they can say that it's premeditation. And on the other side of the coin, you're saying she's going around wrapping up the Christmas decorations. And by the way, remember they said, not only was mom acting normal, but if I'm going to torch the place, I'm not going to tell my sons, all right, see you when you get home. I'm going to say, don't come home for 5 hours. Or maybe you need to go to another friend's after you go to the mall. You don't say, just come home. I'll see you when you get home. That's not somebody who is premeditatingly going to murder her husband. And when you talk about, you're going to get a jury instruction about premeditation, it's going to be, there has to be some time connection involved with premeditation. Everybody has said a lot of things, maybe to their spouse, to their friends, or whatever, that they say in the heat of the moment, or tell their friends in the heat of the moment. But if this happened on January 7th, and she's telling Kate Fox this in the summertime before, that's not premeditation. That's not evidence of premeditation. There was no evidence of premeditation on January 7th. None. Talked about Chief Leach and all of a sudden his sudden memory. Oh, by the way, you do remember that Trevor and Trent also met with the prosecutor and all of a sudden remembered some things that they had never said before. Verge Franks, one of the police officers you saw first on the scene, smelled gas, but that's after Matheny's coat is on Todd Stermer. Didn't have a report, never said it before. I want to just kind of wrap it up this way. In order for them to obtain a guilty verdict, they had to show that the actions of Linda Stermer caused the death of Todd Stermer. The actions can only be she set the house on fire because he died of burn injuries. I was thinking about showing you the video of the burn of the sweats. You've seen it. You know what happens to polyester pants. And the question was, well, if he was on fire, how did the pants not burn? So they burn so easily. And you heard 24 that says, we all know, well, we don't all know, but skin burns at about 110 degrees, 108 degrees. You get 108 degree temperature, your brain cells are burning and dying. Clothes, as it said in 921, ignition temperature, pretty much the lowest, is about 450 degrees. So that can explain the thermal burns, which he said, these were not contact burns. We've all, people who die in a fire when they've been immolated, they look like a burnt hot dog, which explains why the pants weren't burned, which also explains that there was no gas on the pants in any amount that could be related to anything with this fire. Because I wear my sweats Friday, Saturday, Sunday, Monday, it doesn't matter. People do that. You can't tell how long the sweats had gas on them, the last time they were washed, where he was. If he can't rule it out, it's reasonable doubt. And finally, I told you have rights. Linda Stermer has been fighting this since I've been with her for 6 years now. And Skip and our team. So now, excuse me, I'm going to turn her future to your hands. Follow the evidence, follow scientific evidence, follow the objective evidence, and understand how high the burden is to achieve beyond a reasonable doubt. Convincing evidence, a firm and definite belief that any proposition is true, not good enough. If there is any doubt, common sense, where you don't have to throw out reason, that's reasonable. You deserve to be on a jury that holds the government to that burden that our founding fathers set forth. You deserve to be on a jury that holds the government to that high burden on every single fact that they need to show to prove those elements. They can't check a single box. Forget 3 boxes or whatever she was talking about. There's no evidence to suggest that this was an intentional fire. It was such a shoddy investigation by the fire sergeant, fire marshal. People can't do it. And finally, they have to rule out reasonable doubt for every single element. You know why we're here, really? Is because Sergeant Leroy mailed it in. And 18 years ago, he destroyed Linda Stermer's life by mailing it in. So when you're deliberating and you have a conviction, and we said you took an oath to not mail it in. You took an oath, if you have a conviction, to stay as long as it takes and stand up and not be bullied by somebody who maybe wants to go home on Friday and doesn't want to come back because I missed 3 weeks of work already. There's too much at stake. A person's freedom is at stake. Don't mail it in. Todd Stermer mailed it in. Leroy mailed it in. And you know what? He not only did a disservice to Linda Stermer, but to Todd Stermer and to you. Return a verdict of not guilty on all counts. There's a verdict form that you're going to see. I didn't have a chance. We just got it this afternoon. Didn't have a chance to blow it up on a board. Possible verdicts. You may return only one verdict on each charge. Premeditated first-degree murder, not guilty. First box. 2, felony murder, the arson, not guilty. Everything depends on whether there was a fire that was set intentionally and was it set by Linda Stermer. If there's no arson, there's no crime. If there's no crime, there's no premeditation. Put this in your hands to do your job and hold yourselves to your oath. Thank you. Not guilty.
Thank you, Mark.
Housekeeping time, Your Honor.
Break. Okay, I have a juror who needs a break, so we'll take a 10-minute break.
Thank you.
So you should have given them time limits. Good Lord. Judy, do they know what caused that helicopter crash? That's It's horrible. Helicopter crashed in the Hudson River. 6 people died. No, she's not. They don't have time to do rebuttal if they're going to end at 4:30 today. This woman needs to learn. This has been the longest day. Yeah, pretty much, Terry. He went through all 5 things, 5 supposed ways that she killed him and why that didn't happen. He was doing good about the part about why there's reasonable doubt about her setting the fire. And he should have stopped. Because when he got up and he started, he was like, all you have to decide is, was the fire set intentionally? Because the cause of death was thermal injuries. It had nothing to do with the van, but she hit him with the van, but it had nothing to do with the van. And so he didn't need to keep going through all the, she hit him with something, or there was sedatives in a cup, or all that other crap, you know? He could have. But he did say something. Now I forgot what it was. He said something that made me, something I was waffling on. He said something that she told the jailhouse snitch. Well, one was about she hit him with an object, and the detective said, well, could it have been a frying pan? That was one thing, but there was something else. Oh, all the medications and stuff that she was on. And I do remember we talked about how medications can affect your memory and stuff. But he said that she was in jail and they weren't giving her medication. So that also could have messed up her memory, which that's true too. Or she was in jail. Maybe she did it to get favor with the cops. But I think they said that the cops came to her. She didn't go to the cops. But jailhouse snitches are notorious for making stuff up too. So I don't know. But oh my God, 3 of them were children. I've not flown in decades, but I keep telling Travis, if we ever go anywhere that's a long distance, I don't like to drive places. And he refuses to get an airplane because he's afraid of heights. But at this thing everywhere, I don't know what's going on. I don't know what's going on. It can't be a coincidence that all these planes and helicopters are crashing. Okay, guys, I've been keeping my mouth shut the whole trial.
Breakfast champion.
I think Mueller's hot. He's a despicable human being, but I still think he's hot.
Jason. Straightening up the plate. Okay, we're back on the record. Any matters to address before we bring the jury in for rebuttal?
Oh, Lord.
Mr. Mueller or Mr.
No.
Kelly, before we bring in the jury?
How late are we going to be here today? Oh, I didn't think about trains. Yeah, that's an option. My deal is with the fibromyalgia, sitting in a car that long is painful. We drove to New York to visit my brother, and we did stop and spend the night at a hotel, but still. And I even begged. I said, Daddy, because I was working. I was working. And I had my own money. I'm like, Dad, drive me.
I'm not going to address 2.5 hours of rebuttal, but I can't get up here and not talk to you about the misstatement of the law that was made by defense. Sympathy, bias, or prejudice influence your decision in any way. That means sympathy for anyone, sympathy for the boys, sympathy for
I didn't
Sandy
say I
Stermer,
liked them.
sympathy for Ms. Stermer. It doesn't matter. That's not your job. Your job is to find out if the evidence presented checks the boxes and the elements are met. And sympathy does not play a role. I also want to talk to you about reasonable doubt. We have stated it over and over and over. And every crime is made up of parts called elements. Prosecutor must prove each element of the crime beyond a reasonable doubt. Defendant is not required to prove her innocence or do anything. If you find the prosecutor has not proven any element beyond a reasonable doubt, then you must find the defendant not guilty. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of defendant's guilt. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not imaginary or a possible doubt, but a doubt based on common sense and reason. A reasonable doubt is just that. A doubt that is reasonable after a careful and considered examination of the facts and circumstances. All his charts and going over the different types of burdens of proof doesn't change your burden of proof. It is based on common sense. It's not imaginary. It's not possible, but it's based on common sense. So get back grounded with what the judge is going to give you. He made several statements. I'm going to reference them as I just go through quickly, that all you got to do is just find one thing and you're done. Your job's done. No, ladies and gentlemen, that's why we presented all of the evidence. Your job is to take all the evidence, all the pieces of evidence. If you were to take out the fire inspectors, and we just brought in Dardita Gordon that said she cracked him over the head with an object, you found lacerations, you saw the blood on the van, you found the gas on the sweatpants. If you believe that testimony, you could find her guilty. So each individual person that comes into you is but one piece of evidence. Mr. Trinkle is one piece of evidence. Scott Leroy is one piece of evidence. Your job is to evaluate all the evidence. All the evidence. Mr. Leroy didn't do anything wrong. He didn't ruin. I see your face. He didn't do anything wrong by investigating. He's just, you know what? I do things differently today. I should have taken more pictures. I should have done more. He's one piece of evidence. But the interesting part about that is that you can still look at all the other evidence to corroborate some of the things he found. And that's what you need to do. You need to look at. Mr. Trinkle didn't even say that there was a different place of origin other than in the living room. Mr. Trinkle was then wanting you to pinpoint a very specific place of the living room and said, if you can't pick that one little spot in the living room, you can't even declare it an arson, ignoring all of the other pieces of evidence that you guys have been presented. The witnesses that were attacked, what you can also do is you can look at the witness testimonies corroborated by other witnesses. So when you have one witness saying something, and it's corroborated by another witness, and it's corroborated by another witness, that may start to make you feel that that information is credible. Kate Fox identified Chris Williams, told the police about where he lived. They went there and he said, yeah, he's having an affair with her. It's corroborated by more than just one person. Even Tina Benny corroborated that there were photos at the scene. You can look at that to say maybe what Kathy Ogwa said is corroborated by somebody else in determining your credibility and the credibility of the witnesses. That's your job. Your job is to determine the credibility of the witnesses. The boys explained their inconsistencies. They told you this is really the first time, it is the first time that they've been able to come in and testify under oath. They explain those inconsistencies. And you can take that and you can weigh that in terms of judging their credibility. It's you that decides the evidence. If it were just, we have an arson or suspected fire and we hire an arson investigator and he says it's undetermined, okay, I guess there's no crime, we can all go home. That is false. That is false. This is an entire investigation. This is an entire investigation. Even Mr. Trinkle told you this is not a legal determination. That's why you're here. He is one piece of evidence that you can consider. Just one. All the evidence that we presented ties to Linda's intent. Her actions support murder. Her actions support premeditation. These are things that are supplied to you to be able to determine if those boxes are checked. You're not simply here as a battle of the experts. That's not what your job is. That's not what your job is. Your job is to evaluate all of the evidence. His expert, Mr. Trinkle, told you, well, first of all, he denied that if he'd ever been involved in a prosecution where there was an undetermined fire. So basically, if the arsonist is so good that everything's burned up, you can't prosecute. That makes no sense. That makes no sense because you're not even looking at any of the surrounding on a fire. And then when Attorney Blair said, well, what about people versus in this very courtroom? And did you see his pass? I asked you to hold me to my burden. And I told you that I wasn't going to bring in 200 people
StreamYard, stop. Thank
you to take the evidence that you got from me, from this trial, from those witnesses that took the stand in totality, and make your decision. There's no pass here.
StreamYard.
Like I said, you can completely rely on the witness, the person he stated, if there's one reasonable doubt, your job's done. No, go home. No, I wish it was that easy. You have to consider everything.
She could have gone to the police
all the
herself.
evidence.
Nobody would have known.
One reasonable doubt in your law.
It's a misstatement. It's absolutely wrong.
I'll give these are closing arguments or arguments of counsel, but I'll give you the instruction on reasonable doubt, jury, when you go to the jury room, or before you go to the jury room.
If you have reasonable doubt about an element being proven, that's the law. Not if you just have one reasonable doubt about a particular testimony, particular witness. He brought up that Linda was in the laundry room. She can't be her. She's downstairs. We talked about that. We talked about how the vapors could have ignited. We talked about a possibility of where that could happen. But you're also then relying on Linda's statements that she was even in the laundry room. A person who only says statements that don't incriminate her. So you can certainly consider that. You can certainly consider her credibility with everything else and all her descriptions and whether you believe her or not. Asking you to rely solely on Mr. Trinkle. Asking you to forget that you're the jurors, you're the judge of all the evidence.
She worked in a different town than she lived in.
No one person determines the verdict. I mean by that, I mean witness. It's taken as a whole and what you feel elements are met. Possibilities. Said you can't consider possibilities. Well, you can consider possibilities if they're backed up by other evidence. You consider the possibility that that gasoline was purchased by her because it's backed up that she bought it. You can consider the possibility that the 1 gallon gas tank can was used by her, because it's a possibility, it's on scene. And you can consider it a possibility because there's no other reason that gasoline should have been on Todd Stermer. You have other evidence that talks about all the other clothing that Matheny had put on him did not test positive for gasoline. You have evidence that that duck boat never ever had an engine. You can use other evidence to make your determinations, and what would then lead towards a conclusion. You consider everything. He wants you to believe that Steve Leach came in and relied on Scott Leroy's report, and voila, there was gasoline, and so he smelled it. Well, you have other evidence supporting that there's gasoline on the clothes. You can consider that. Ladies and gentlemen, they lived in this house for 3 years. It took a long time to build, but they lived there for almost 3 years. No reported issues, no reported fires. And in the documents that you received on the building from the building inspector, there's several written letters by Linda of why they're asking for delays before they moved in. And they detail out Todd Stermer's knee injuries. It wasn't that they were saving up and trying to, put in the cheapest materials or buy as they go. Read her letters. The ones to the building inspector are in there. They're her detailing out how Todd hurt himself, and they had to take a break, and then they needed to restart. Either Miss Stermer is the most unlucky person in the entire world, or all these dots that he talks about lead to the next dot, and lead to the next dot, and lead to the next dot, and show that this is more than just an unfortunate, unlucky series of events. There's been lots of testimony that Linda Stermer becomes overly emotional, only shows emotion when she's pressed. She can turn on the emotion to avoid the questions. Connie is very emotional in that 911 call. What you may be hearing from Linda is that she's scared she just got caught. All she's doing is wailing. You don't hear her talking.
You're wailing because her husband's on
She
fire.
might be horrified at her own actions.
God.
Might not have expected everything to go on the way she wanted. Certainly been enough testimony for you to consider. She might be trying to cover her own tracks. Maybe doesn't want to talk to anybody, wants to play the part. She didn't hide baseball cards, wedding ring, gun. All that can be replaced. Those didn't mean anything to her. There was a little bit of mistestimony or misstatement. Ms. Fox said that she wanted to go to the house to find the cup because Ms. Stermer had put something in there. I think she said a tranquilizer. You can check your notes. But changed her mind. And she didn't want the police to find it. That's why you didn't find it in the toxicology. I doubt that Kate knew what the toxicology was when she made that statement. Kim Thompson got to that scene and looked at Ken while she was on scene, and she said, something isn't right. Something isn't right. She didn't need to talk to anybody else to figure that out, that something wasn't right. And then as all the pieces of evidence come in, gasoline on his underwear, gasoline on his socks. Yeah, you're darn right. Something's not right. Ms. Stermer, he said, is either the greatest actress or is genuine. Maybe she just got caught. Maybe she didn't expect to have to try to kill him 3 times before it was completed. And that's what caught her off guard, got her upset, and caused her to act the way she did. Mr. Leroy was also a detective. He was a sergeant with the Michigan State Police. He also then approached this for looking at the evidence that he found. This is why he collected the gas can. No matter how hard you try, ladies and gentlemen, you cannot explain the gasoline on Todd's pants, his underwear, and his socks. Mr. Leroy, Sergeant Leroy, also testified that he worked with the insurance company, got all their documents. They talked about a form that they filed with the insurance company. He had access to all their documents. He reviewed all those documents. And when asked by Attorney Blair if he would change any of his opinions after reviewing all those documents, his answer was no. He had access to Mr. Willison, to Mr. Shinsky, and Greg Stornzan's, any of their documentation, any of their pictures, any of their information. He had it all. You, as jurors, can look at those pictures and see if that area of origin makes sense. You can evaluate that with Linda's statement. You can make those determinations. Now, you can use the experts' advice, opinions, because that's what they are, is opinions, to help you make those determinations when you're going through those pictures. But you can look at that evidence as well and say, does it make sense? He wanted you to focus on the fact that you just can't find there's a source, didn't know how the gasoline gets there, but consider it when determining it in his data. And so because he can't say that the gasoline got there a certain way, then you must rule it out. No, you can still consider it in your data. You can still consider it as part of this. I think Mr. Trinkle and Mr. Leroy both agreed that the ignition source could have been the fireplace. A lot of talk about not ever finding what the ignition source was. I believe both of them testified that that was an open flame in that room and was the ignition source. He wants you to focus on the contamination. However, if you look at the other testimony that's been provided to you, that boat's ruled out. And Mr. Matheny's clothing was ruled out through testing. Mr. Z, or Professor Z as he calls him, he can say that he thinks the injuries came from the van, but he couldn't match where or go on the either sides of the head. He's not a forensic pathologist. He didn't examine the body. There's a total separate laceration on the back of the head that I questioned him about. I said, you can't even see it in your picture, can you? Because he's laying on it. You can only see the top laceration. He was speculating. He didn't even concern himself with the other injuries on the body and where that blood could have come from.
And it looks tired.
You're also going to get an instruction on credibility and how to judge credibility. One thing that you can read for yourselves is that the judge is going to tell you, you can view how an expert answered questions as a way to try to determine their credibility. Mr. Trinkle didn't answer questions directly when it implicated his client. He danced around. He was very happy to answer any questions he felt didn't implicate. Yet he also agreed on many points of Scott Leroy's investigation. He also reminded you that his conclusions are always right. But again, he is not the only person to consider in this case. This is not, his opinion is not a legal determination. The defense wants to put all their eggs in one basket. Rely on Trinkle, can't say it's an arson, because ignore all of the other evidence. And if you don't have an arson, you got no crime. That's not what you're here for. You're here to look at premeditated murder, and you're also here to look at the felony murder and all the evidence presented to you.
That doesn't make sense to me.
He also went on and on and on about this unfinished living room, yet the boys testified, one said it was 95% done and they were getting ready to paint. He did say there was no carpet. He did say there was no carpet, there were just area rugs. But his testimony was that the walls were finished and they were getting ready to paint. Defense read a little bit of the testimony from Dr. Markey, just the sentences that fit his narrative. But look at his report, look at your notes. And when I asked if you can determine if those lacerations came solely from the van, he said, no, I can only say it's blunt force trauma. I said, can you determine if they came before the fire or after fire? He said, no. He said, no, you can only say it's blunt force trauma. And is also in his report, some of those rib fractures were not consistent with CPR. He detailed it out. He detailed it out. Doesn't want you to rely on Dardita because of her medical conditions, yet Dardita had some very, very, I would call it insider information. And when police pressed her, you have her transcript, pressed her and said, is it in a frying pan? She said, no, she just said she hit her with an object. Read that. She knew what Linda had told her. He is correct that Todd Stermer died of thermal injuries. But that doesn't mean you can't consider the fact that she ran him over, jumped on his body. You can still consider all of that, especially with premeditation. He died from the injuries inflicted in that fire. If you find that she intentionally set it, then that's where you go to count 2. And count 2 is the felony murder in the commission or the attempt on the arson. So no arson, no crime? It's not true. You have to weigh all the evidence. You have to weigh all of the evidence, all of the elements, and you need to look at premeditation. You need to look at the attempts, the planning, and all that goes towards premeditation. I'm asking you to make sure you read the law and know why you're here. And you're here to evaluate everything you heard separately. You decide what you want to believe. You decide what's credible. And you decide if, based on what you think is credible, if those elements are checked. That's your job. That's your job. It's not to be narrow-minded.
Exactly.
It's not to have tunnel vision.
I think her charges are
It's
wrong.
to take everything you heard and evaluate it. That's why we brought in the people that we did. Each individual piece is important. No piece is more important than another. No piece. You decide what's important. You are the jurors. You are the ones making the legal decision. I appreciate all your time. Thank you.
First degree murder is premeditated. Felony murder is if it was done because of the arson. If she didn't, he died because of the fire. The van didn't kill him. So how is that? If she didn't set the fire, then how is she charged with first degree murder? The other charge should be attempted murder for hitting him with the van.
I had every intention of reading to you final instructions, but I'm looking at all of you, and you look exhausted. So I'm going to send you home for the evening. And when you come back in the morning, we're going to go right into final instructions. I'll release 3 of you as the alternates and then send you off for deliberations. Okay? Remember the rules. I'm not going to read them all to you again, but absolutely no media observations or talking to anybody. Okay? Thank you.
No, it's not a lesser included. There's 3 counts. This is what they said. She's charged with 3 counts: first degree murder, felony murder, and arson. But you can't find felony murder unless you find arson. But that's what she said in opening. She's charged with 3 counts.
Okay, audience, if you could remain in the courtroom maybe for at least 3 or 4 or 5 minutes here so we can get the jury out, please.
Yes.
For their kindness.
And it
You don't have to
said-
remain standing though.
count 2, felony murder,
Yeah, and then George will have to figure out.
Oh, I don't know.
count 2 is felony murder. And for that to be true, you have to find that she caused his death or intended bodily harm or created a chance or risk of bodily harm or death by committing arson. And count 3, which is arson, burn, damaged by fire or explosion, burn property of a dwelling, intended to burn, committed act with high likeliness to burn. No, the 3rd count is arson, but you can't get felony murder without the arson. Oh, cool. Neat. So, first degree murder, she caused death. She intended to cause death. It was premeditated, deliberate. It was caused by real reflection long enough to consider her actions. But what doesn't make sense to me is if she didn't set the fire, how do you get first degree murder? Because that's how he died. That makes no sense to me. Because she didn't kill him with the van. She didn't kill him by hitting him in the head with anything. She didn't kill him by drugging him. So even if she had done those other things, if she didn't set the fire, where do you get first degree murder? So there should be an attempted murder charge if they think she did those other things. That's confusing to me. Unless they're just so confident that she set that fire that they're not going to even entertain that. Or they think it'll be confusing to a jury if they put attempted murder in there. I don't know. But I don't see any proof that she set the fire. Did she do some strange things? Yes, she did. But I don't see proof. And they're telling you to believe some things she said, but not other things that she said. And they're telling the jury, which they always tell juries, you're the trier of fact. You get to decide what witnesses are credible and what witnesses aren't credible. And usually, if you think a defendant is lying, they don't tell you, well, believe some of what they said. This is such a weird case. I like the ones like the Rose Petal and the, what was it, Jason Chin, the suitcase by the river murder, whatever, where they're like, yeah, I did it, but I did it for a reason. I like those. Because, like, I get what the prosecutor's saying, because part of me wants to say, of course she did it. All the little things that add up. But even in her closing, she's like, well, she could have knocked the candle over. She could have done this. She could have done that. They don't even know how the fire started. And the kids testifying, that was just a waste of time. Because, they lived with Todd's mom. Who knows what she told them? Their testimony is tainted. They've been told all kinds of stuff over the last 18 years. Plus, their mom did go to prison for it for a little while, too. So, oh my God. The copter broke apart in midair. Yikes. So that's got to be some kind of an inspector's fault, or I don't know. I don't know anything about aircraft. But I think somebody failed an inspection and didn't do anything about it. Why else would a helicopter fall apart? So how long do you guys think the jury's going to be out? You think it's going to be quick, or you think they're going to pour over? Did you hear her when she got up to do a rebuttal and she said something about Leroy making a mistake or whatever, and she goes, I see your face? Like, one of the jurors must have made a face like they believe that Leroy made a mistake. Did you guys hear that? What did you think about that? I bet she went back to the desk and was like, oh my God, we're screwed. I hope so. I hate waiting for. Yeah. And I know this is TV stuff, but on TV, on cop shows and stuff, and CSI and all that, when they talk about fires that have been set with accelerant, they always talk about pour patterns. Is that a real thing? Does anybody know? Like, would they have seen something like that if she poured gasoline? But they're saying they didn't see any gasoline, any use of accelerant at all. And, he's right. He's right about that, wearing your sweatpants over and over again. Because I do that with like shorts, sweatpants, like those kind of, bum around the house clothes, like, like you wear them 3-4 days in a row, and then you're like, okay, these are getting gross now. I gotta put them in the wash. So maybe he had been wearing the sweatpants for several days. He'd been out working on the tractor, or well, it was winter, so he wouldn't have been on the lawnmower. Probably wouldn't have been on the tractor. I don't know. But maybe for some reason, gotten gas on them somehow. And it wasn't that much, I don't think, from what I understand, that it wasn't that much gas on them. And they hadn't been washed. That's a possibility too. So if they didn't find any like, and who knows how long that can had been in the front yard. It had a broken nozzle on it too. I mean, maybe they just, because there was a fire, and then they were like, oh, look, there's a gas can. It's just, they're stupid little things that may not have anything to do with anything else, that they're just putting together because this happened. Like, just because said, maybe they're just because she lived. And I don't know. Because they kept saying that there was, what did they call it? Fuel oil. They just called it fuel oil. So they said that she kept saying that he had gone down in the basement to bleed the line. But then the boy said he didn't go down in the basement the night before. So maybe it wasn't the night before. Maybe it was the night before the night before. And he got some on his sweatpants. But then they keep saying gas. But then they keep saying fuel oil, like back and forth. So I don't know which it was. It's like they're using them. And then they said it could have come from the boat. And then they were like, well, but there was never a gas engine never a gas motor on the boat. So maybe there was some gas on the boat. I don't know. Like, that's reasonable doubt. So like, I would hate to send a woman to prison for the rest of her life when we've still got all these questions, and nobody knows. It's just like, and I know some people disagree with me on this, but that kid, Griffith, Colin, was that his name? The thing with his mom, she was cray-cray. So nobody knows what happened in that house when she went in there. She was like yelling at him and stuff outside of the house. And then they went in there and she died. And nobody knows what happened in that house. Yeah. That could have happened. And maybe it didn't happen the night before. Maybe it happened the night before the night before. And they just got the days mixed up. Because didn't one of the kids say that they had been having trouble with it? It had been doing something and that he fixed it? So maybe it was a different night. They just got the night wrong. And he hadn't washed the sweatpants yet. And he was wearing them. and they mistook the fuel oil for, I don't know anything about that stuff. I live in Florida. We don't use the heat very much. We definitely don't use anything that's gas powered or kerosene powered or anything like that. So, I don't know, but it could be a simple explanation like that. So, but with that much, I mean, I know I'm, I haven't got to go look at the evidence, and I don't have a room full of 11 other people to discuss it with, but there's too many questions. So, there's just too many questions. And I just don't like the idea of saying someone is guilty when you have that many questions. And another thing, when I look at cases like this too, and in this one, this might not be the right thing in this case, but I could be totally wrong in this case. But I also think, are they going to ever do it again? If they did do it, are they ever going to do it again? So I look at it like that too. But however, who knows? If she did do it, she might do it again. But that's what I think about with the Menendez brothers, because everybody's like, oh no, they killed their parents, you shouldn't let them out. My thought with them is they've been punished enough, and they're never going to do it again, so you might as well let them out. I mean, Gypsy Rose, what's her name? Gypsy Rose Blanchard. She's out. I'm not so sure she deserves to be out. I feel sorry for her husband, because she played him like a fiddle. I think she just married that poor man, because when you get paroled, it's easier to get paroled if you have a place to go. And her being married made it easier for her to get paroled. And then she promptly found a real boyfriend that she cared about and divorced her husband. So for the longest time, I was like, she did what she had. Not that I approved of what she did, but I was like, well, she did what she had to do. They did have premeditation, yeah. But I still feel like they thought that was their only way out. And yes, they should have been punished, but I don't think they deserve to still be in there. I think they've been punished now. Oh, I forgot to. Oh, you're wonderful. Thank you. I forgot to text him and tell him to bring me coffee creamer, and he remembered. Yeah, that's true. Part of parole is. But see, they don't get parole. But I think they should let them out. Florida doesn't have parole, because we mean business down here. That's why everybody was like, well, Sarah Boone's just going to get parole in 30 years. And I'm like, oh, no, she's not. We don't play down here. Life means life in Florida. Oh, what was I watching? Oh, it was something, I think it was on Biggins' channel. And it was on Biggins' channel. There was a lady, in Ocala, and her boyfriend had gotten into a fight, and I guess she slapped him or pushed him or something, and so somebody had seen them and called the cops, and she scratched him. I don't think she scratched him on purpose, but when she pushed him or slapped him or whatever she did, her nails scratched him, so she got arrested. And she was a bartender, and she was crying. I don't understand. I don't know what's going to happen. Can I call my mom? I don't know how this works. Am I going to get bail? Am I going to be in prison? Because she said, I've never been arrested before. I don't know how this works. And she was just bawling like a baby. And she goes, I used to work in a prison, but I don't know how this works. I don't know what to do. And somebody was like, she used to work in a prison, but now she works at a bar. Why would you quit a job in a prison to be a bartender? And I was like, are you kidding me? Would you rather work at the prison and take care of Sarah Boone, or would you rather be a bartender, get good tips and free alcohol? Because Sarah Boone's in Ocala, where she worked at the prison. It's like, if I worked at the prison in Ocala, I would quit too. I don't want to be working where Sarah Boone is. No way. Can you imagine? Oh my God. No. Yeah. Yeah, they do. They do. They get good pensions. The I don't know. The state has really good benefits. My dad, when I was on his, because my dad was highway patrol. I hope not. Well, I don't have it anymore though, because, adult and all that. So and dad's gone now too, but I was on his insurance. I guess, was I? So I was 21, I guess. Good insurance. The state has really, really good insurance. So, and my dad got disability and his pension. And I was an RN. He made more money retired than I did working as an RN. Yeah. So their pension and their benefits are excellent. I don't know about the pay, but benefits with the state of Florida is amazing. Absolutely. So, but still, is it worth it if you gotta be around people like Sarah Boone all the time? I don't know. Okay, guys. Well, I'm gonna go. I will see you all in the morning. Do you guys want to do jury instructions tomorrow? I don't know. Well, I guess we can talk about it tomorrow. I kind of do. I don't mind jury instructions. Because it's a little different depending on what case you're watching. Some of it's boring because it's the same old, but because, I don't think I've ever watched an arson case, so I'm kind of interested in the law about arson. Okay, I will see you guys tomorrow. Bye, love y'all.